no party who is. So anybody who is not a party to a contract cannot enforce the provisions of that contract. I mean, the principle of privity of contract. So NCDB cannot interfere with a contractual relationship, but we can advise if we see that strict enforcement of contractual provisions are likely to stifle businesses. So that's just a mediatory role. Parties are free to choose to take or reject it. It played out in Ladol conflict with SFG, the Chinese, the Korean company. Now that takes me to your first question. And when you were putting the question, I was getting worried myself that this attorney seems to be representing another jurisdiction instead of Nigeria. We should worry about how we benefit from the African Free Trade, Continental Free Trade Agreement. That should be what should worry all of us as Nigerians. What do you have that other countries can actually require? Otherwise, we will lose out completely in it. So when you express so much anxiety about what the body is doing to ensure that we will also give consideration to other African countries, well, that's legitimate, but first and foremost, care for your people. Now, that takes me again to the Act. Section 3, Section 12, Section 58 talks about forced consideration for operators, for Nigerian service companies, for Nigerians in training and employment. If you read it, I mean, the key expression there is forced consideration. As lawyers, I'm sure you know that forced consideration does not necessarily mean exclusivity. In fact, when the Act talks about exclusion, in terms of operations in the swamp, it says it shall be left exclusively for Nigerians who play in that space. Many a times our trading partners come with this kind of argument. I mean, Nigeria is not strictly a protectionist enclave. Local content, as we call it here, is done almost everywhere, including the US. Those apostles and champions of global free trade and globalization practice America first, practice local content. So what we are doing is a hybrid. Say, give first consideration to Nigerians when it comes to employment, because in my presentation, I hinted that local content and energy issue are for us matters of national security and economic survival. If we don't pay attention and come out with strategies to generate jobs and employ the army of young people that we find in the length and breadth of Nigeria, we wake up one day and this country descends into the kind of civil war that we cannot define. Already it's happening with the insecurity we experience everywhere. So I hope I've answered that first consideration does not mean exclusivity, and that we should worry about what we are going to, how we are going to benefit from after. And leave the other ones. But what are we doing for them? We are helping those who have recently discovered hydrocarbon resources to articulate strategies and develop even their own local content laws. We are supporting Uganda. We are supporting Senegal. We have been supporting Ghana and all other African countries. I hope with these few points of mine, I have been able to convince you and not confuse you. Thank you.
Thank you very much, sir. That was quite an insightful kind of explanation. Is Dr. Subai ready for his presentation? Okay. Is he ready? Okay. So we'll take the presentation of Dr. Subai. He holds a Doctor of Philosophy from the Newcastle University and a Master's of Law from Obafemi Awolowo University and a Bachelor of Law from the Rivers State University. He was called to bar in 2003. He's currently a senior lecturer, in the Faculty of Law of the Niger Delta University and an associate with the E. Boma Peter and Associates, a particular law firm with interest in corporate law, oil and gas, property, and litigation matters. He has research interests in energy and natural resources, competition law, and corporate law. He has extensive research and teaching experience both at the Niger Delta University, Federal University of Turkey, and St. Augustine University in Tanzania. He's also a member of several professional bodies, namely the Nigerian Bar Association, the Nigerian Association of Law Teachers, and the Institute of Chartered Secretaries and Administrators. He has published widely in the oil and gas space, ranging from corporate law and labor law, and is the author of Local Content Oil and Gas Law, Local Content Oil and Gas Law in Africa, Lessons from Nigeria and Beyond, as well as Dr. Subai's Principles of the Nigerian Company Law. Dr. Subai has also attended several conferences within Nigeria and the United Kingdom, and has presented several papers at the University of Bristol, Northumbria, Newcastle University, as well as other institutions in Nigeria. We'll be having Dr. Subai for the next 15 minutes, please. Thank you.
Good morning, everyone. It's so good to be here. Thank you for having me. I salute my co-presenters for your erudite presentation. I wish I could have been there physically myself, but for some other commitments that kept me bound in Port Harcourt. So much has been said, and I will, because my time is short, try not to overflog some of the issues that have already been raised, other than to point out that we are currently in a race against time to catch up with the rest of the world with respect to energy transition and to establish that the African continent continues to, currently close to 600 million people in Africa live without access to electricity, and more than 900 million do not even have access to clean cooking solutions. The COVID pandemic has only worsened that, because as a result of the pandemic, it is estimated that over 30 million Nigerians have been added to the over 600 million who do not have access to electricity. And so it is very imperative for Africa as a continent to put in place measures to address its energy challenge. But at the same time, we are faced with the paradox of the global transition to cleaner fuels, and the, like Mr. Onyeso pointed out, the demonization of fossil fuels, which since the first decade of the past century up till now had been the dominant energy source for the global economies. But we are seeing a shift from fossil fuels, from petroleum, crude oil, to renewables, similar to what happened to coal during the first decade of the 20th century. You know, so this puts us in a delicate position. For, on the one part, we know that petroleum is not just a source of energy for most African economies. It is also a major financing source. It's a major contributor to energy and to also the funding of governments. Nigeria, for example, continues to rely extensively on petroleum for the funding of government. And so if we are to make this shift quickly and suddenly, we know that we are going to have significant and adverse impacts on our economy. And so there has been some form of compromise. Scholars and researchers have tried to find a middle ground in natural gas. So if we are to move away from petroleum, from crude oil, can we at least stay with natural gas in the time being until we are able to come up with solutions that are synonymous or similar to what most of the West and the developing countries are trying to put up? That is to rely almost entirely on renewables. The interesting thing, however, is that which is something we should take note of, is that even for these developed economies, while they continue to harp on the need to move to cleaner sources of energy, they have not entirely left their fossil fuel reserves. The Russian invasion of Ukraine, has brought some instability and some uncertainty with respect to the sources of energy for Europe. And surprisingly, some European countries are beginning to consider resorting back again to coal as a means of addressing the risk and the challenges that have arisen as a result of this invasion. What does that tell us? It tells us that even if we will buy into moving into the cleaner and renewable sources of energy, if I will call it a rhetoric, there's still need for us to do so sustainably, progressively, and over time, considering again the fact that petroleum and that Nigeria hardly contributes, Africa hardly contributes to carbon emissions and to climate change. As someone has also pointed out, Africa continues to contribute less than 4% to global warming and to climate change. And so for me, there shouldn't be a rush. We shouldn't be in such a hurry to dump these fossil fuels, which are the mainstay of some of our largest economies, or which contribute significantly to the GDP of some of our largest economies like Egypt, Nigeria, Angola, Sudan, and the like. That is the first point I want to just emphasize. And also to emphasize that we should continue to develop natural gas as a transition fuel until such a time when we're able to also move to renewables. Thankfully, the PIA, the Petroleum Industry Act, as has been pointed out, has significantly focused on the Nigerian gas framework. Recall that prior to the enactment of this law, Nigeria did not necessarily focus on developing its gas resources. Even the Petroleum Act of 1969 was largely crude oil focused, although it mentioned gas in the definition of as part of petroleum, but the whole gambit of that law was focused on the development of Nigeria's crude oil. So over time, Nigeria has not been able to harness our vast gas potentials and resources, but thankfully, there has been a continuous progressive and shift in that direction. And the PIA, I would say, is the crux or is the climax of some of these initiatives that were introduced, first of all, in 2008 and on. So we should look for means to harness the potentials of our gas resources as a viable energy source and also as a viable resource, economic resource. We should try and do that. But again, in addition to that, there's also need for Africa to have its eye in the future in order for it not to be left behind. And so this is where we need to look for how to harness Africa's unique abundance of untapped energy potential. The African continent is blessed with sunlight. We're blessed with sunlight energy, which I think we can look for how to develop them progressively. If you look at one of the slides there, that should be slide 7 or 8 on some of the suggestions I put there. I say we should scale up our national and regional utility scale renewable energy generation capacity. As a continent, we should look for means to strengthen national and regional transmission and distribution systems while also decentralizing renewable energy solutions in order to impact on rural regions. Now, where does local content come in? I will try and settle here for a while before I move on. Where does local content come in? We all know that local content is all about utilization of local suppliers, local goods and services, local contractors, because of the potential for job creation, skill creation, and for linkages to other relevant sectors. If we're able to develop our local content significantly, we will be able to also export the skill sets gained from involvement of Nigerians in various sectors to other sectors. A good example is Norway. When Norway discovered oil in 1969, it was not very difficult for them to develop capacity to conquer and dominate that sector, because as far back as 1905, they had started developing their hydropower technologies. And so they simply exported the capacities that they had gained in the hydro sector to their oil and gas sector. And by 1981-82, Statoil of Norway had become the dominant force in that industry. So again, for Nigeria, local content is very important, not just because of the job creation and the funds that are retained in country, but for me, more even importantly, the fact that the skill sets gained can be exported to other sectors. And this is where, again, the NCDMB coming, the Nigerian Content Board, this is where it comes in, because the NCDMB is not just a regulator, but as has been pointed out by successive speakers, is also a local content developer. If we are going to successfully transit to cleaner fuels and to other sources of energy, it is important that as a country, we should develop our competencies and capabilities significantly. Yes, all the oil companies, or most oil companies now, have some form of local content departments, and I think that is a major milestone or consequence of the NOGIC Act, that most oil companies now attempt to have local content departments and all that. But the NCDMB is able to come in harnessing the various competencies of Nigerians in advancing Nigerian involvement and integration in the oil and gas sector, particularly with respect to development and capacity and all that. So the regulator is able to partner with industries and the private sector in driving investments in the oil and gas sector. And this will also, over time, if it is sustained, it will also enable Nigerians to develop competencies and develop skill sets that will help in the industry. But there is need to form or to arrive at some form of compromise. There is need to arrive at some form of compromise. If we over-regulate, then we may stifle innovation, and we may also frustrate other companies that want to operate in the country. But again, if we relax and allow people to just operate freely, we will also over time discover that we have not been able to, consolidate our competencies. So what does the NCDMB do? The NCDMB was established in 2010, again, as has been pointed out by some of the speakers. And where it can really come in helping Nigeria as a country to transit in terms of its energy is in the area of development, research and development and all that. I'm an academic, and so I'm looking at it from the academic perspective. R&D is a critical component. Can you move to the next slide, please? R&D is a critical component of local content development. It is a prerequisite for the development of new and innovative technologies. And this requires sustained investment in training and retraining of staff and in groundbreaking research aimed at combating local problems, among other things. Today, we know that the most vibrant oil and gas companies in the world are also very strong on research. From Petrobras of Brazil to Aramco of Saudi Arabia, all of these companies invest billions annually in developing competencies and capacities. And if the NCDMB is able to focus strongly in this area, then it will be the anchor institution for helping Nigeria to transit from just being a crude oil country, a country that is significantly dependent on crude oil, to a country that is now able to expand its horizon to other related sectors as well. And for me, I think I would want to suggest that one key suggestion I have is that the NCDMB, the scope of the NCDMB should be broadened, not just at the level of the management of the institution, but also from the legal perspective. There's need for the NOGIC Act itself to be altered, if I use that word. We should alter the law, we should amend the law in order to broaden the scope of the NCDMB, not just to be focused on oil and gas, local content in the oil and gas industry, but local content in the energy sector. This will enable the board to also monitor and ensure that the local content is carried along in other related energy sectors. Next slide, please. Interestingly, the NOGIC Act focuses extensively on advancing local content and on also mandating the NCDMB to advance research. So if you look at Section 70 of the Act, for example, the NCDMB is mandated to conduct studies, researches, and investigations that may further the attainment of the goal of developing Nigerian content in the Nigerian oil and gas industry. You look at Section 88B, also provides that planning, research, and statistics should be one of the directories of the board, while under Section 36, the minister is mandated to make regulations with requirements and targets for the growth of R&D in the oil and gas industry. So there is significant focus on research in the Act. There is significant, not just on research, but also on training. But what is now required is to do this with a broader scope, with a broader mindset of not just crude oil and natural gas, but also other relevant energy-related sectors. Please move to the next slide. The challenge now is, if you go, okay, next slide, please, where I talked about the expanded scope of local content, expanded scope of local content. The NCDMB is the only institution, please, the next slide. Okay, yes, thank you. The NCDMB currently is the only institution which Nigeria has for driving local content. We have local content provisions in some other related laws, like the energy sector, as has been pointed out, the Cabotage Act with respect to development of cabotage and all that, the National Information Technology Development Agency, in their guidelines, they also have some provisions with respect to local content. But currently, there's no other institution in Nigeria that has the mandate to drive local content. There's no other institution in Nigeria that has the mandate to drive local content. And I think this is where it is imperative that we should expand the scope. We should expand the scope of the board. We should expand the scope of the board. Why is that so? Because the NCDMB already has experience. We're talking about 12 years experience of being involved in driving local content in the oil and gas industry. Number two, it has capacity. It has a skill set which it has been able to develop, and it will not make sense to establish other local content agencies to drive the energy transition in other sectors like electricity and all that. Rather, what I'm proposing is that the NCDMB should broaden its scope. Its scope should be broadened in order to enable it to also be involved in these other sectors. Now, you can go to the next slide. There have been some issues, however, with local content. Local content is not without its criticisms or detractors, as the case may be. There have also been issues with respect to capacity. There's the issue with local content, and after the issue with local content and even the WTO, some critics have pointed out that the current NOGIC Act will significantly violate provisions of the WTO regime. And AfTA as well. But I want to just point out that if you critically look at some of these documents, particularly the WTO documents, you will discover that we have a lot of policy spaces. We have a lot of exceptions, which allow countries to still be able to enact local content legislation, particularly developing countries, developing countries. And I am proposing that Nigeria should take advantage of those policy spaces in driving the local content policy, not just in crude oil, but like I said, in other relevant sectors. The challenge now has to do with AfTA, because AfTA, we are now coming closer home. Nigeria is now a signatory to the AfTA agreement, which seeks to integrate the 54 member countries of Africa into a single free market and all that. And if you critically look at the provisions of the NOGIC Act, it would appear again that some provisions, not all, but some provisions may be in violation with the AfTA provision, but we still need to do some critical analysis in that respect to ascertain if really it is in violation of AfTA. But should we abandon our local content law because we have signed AfTA? I think not. I think not. For one reason, we still need a local content law to act as a safeguard in order to prevent other countries from using our fellow African countries as a conduit pipe to bring in goods into Nigeria that ordinarily shouldn't have been brought in if they were coming out of Africa. So it is important that the NCDMB be ever more watchful and collaborate with other agencies such as the MPA, the customs, and NIMASA and the rest of them to ensure that AfTA is not violated through the back door by countries that may attempt to come into to bring in goods or services into the country through the back door. Secondly, just to also point out that even though we now have the AfTA law, many other African countries also have local content laws. From Ghana to Angola, from Kenya to Uganda, a number of them have done this. What we simply need to do is not to jettison our local content policy, but rather to see how to integrate them with AfTA, to see how we can come to some agreement, because the coming on stream of the Local Content Act has significantly impacted Nigeria. The benefits of local content, I don't have time to begin to point them, but they are out of this world. They are very, very significant, from integrating Nigerians into the oil and gas industry, from even building confidence of Nigerians to now take on projects which hitherto had been kept almost entirely for international oil and gas countries. So I just brought some suggestions forward. Last slide, please. Some suggestions on the way forward is that Nigeria should continue to strengthen capacity. This will require a deliberate, conscious effort in building research institutions, and also in developing the universities, endowment of funds and all that. Also, the NCDMB should continue to collaborate with the industry and should not rely entirely on sanctions, which I believe they are already aware of, but should continue to collaborate, because if you look at other countries that were able to develop local content, a country like Norway, for example, they relied entirely or significantly on collaboration rather than on sanctions, and still were able to develop local content. But countries which decided to rely almost entirely on law, like Brazil, for example, was almost frustrated because their undue reliance on top-down legislations nearly frustrated and destroyed their oil and gas industry. But thankfully, they've made some reforms in that regard. And the NCDMB also should be strengthened, and it should continue to operate independently of the industry. There must be efforts to protect and secure the NCDMB from the industry. You know, I am aware that the NCDMB currently is partnering with some oil and gas companies in refining and all that, that can raise some red flags with respect to its independence, because how can a regulator also be involved in partnering with a refinery or partnering with an oil company? So those are things that I think should be looked at. If we should have two major strands of the NCDMB, one should be involved in monitoring, one should be involved in local content development. They should be independent of each other so that the regulator can effectively enforce the provisions of the law, even when a subsidiary or even when a partner of the board is in violation. Otherwise, there is a possibility for some conflict of interest and all that. So we should continue to see how we can externalize the functions of the NCDMB to other related subsectors. Because of my time, I've overshot my time by 5 to 7 minutes, so I want to stop here. Thank you for having me once again.
Thank you very much, Dr. Subai. That was quite a very insightful presentation. Before we, get a reaction from the audience, I'd just like to hear the thoughts of Mr. Naboth on some of the points raised.
Okay, thank you so much. Let me start with the last one because of recency effects. Yeah, quite frankly, from the point of view of a legal scholar, raising issues of conflict of interest is significant. And it's true, and I mentioned even in my own presentation that the board, as part of its role as a catalyst is in chemistry, that force which speeds up chemical reaction. So because the local content board was created as a child of necessity, the role of the agency is dual. One of the roles is to regulate, and the other one is to promote or support, which is where the catalytic role comes in. So in our support for some of the investments or areas that you hear, like LPG, like modular refinery, and other gas processing plants, these are strategic and intentional interventions by the board. First, to speed up government policy. You heard a lot about the gas policy. Those policies will not leave the ground if there is no catalyst to cause it to move. So NCDMB is playing that kind of role. And in most of those investments, what the board has done, conscious of the possibility of conflict of interest, is that our involvement is time-bound for a short period of time, just to make investors that are hesitant to bring in money, put it, and have the comfort or assurance that the government backing is involved so that the investment can take off the ground. There are clauses in those relationships which clearly delineate when NCDMB will exit and its equity is released to the market to ensure that conflict of interest is minimized. Another important issue raised by Dr. Subai is what happens with, there are concerns, again, about clauses in the Act which might impede on commitment under the AFTA, even on the WTO obligations. Let me begin with WTO. Sometime in 2017 or 18, Dr. Ibe Kachukwu, then the Minister of State for Petroleum Resources, and Engineer Wabote and others went to WTO as a consequence of invitation to the board to clarify why this law, the local content law, will not be seen as in breach of Nigerians' obligation under WTO. The argument was forcefully made, just as Dr. Subai hinted, that there are exceptions in the WTO obligations which allow countries, developing countries, to enact laws of this kind if it is intended to achieve security of purpose. Recall that in my presentation I mentioned that for Nigerians, and that point needs to sink in, local content is a matter of economic imperative. It's tied to our survival. and it has a nexus with security. So if we're not able to dot that line between local content and security, I say this nation will be consumed, and the signs are ominous. So that's why our trading partner, the US and the EU, had to back off, because our argument is predicated on security. And that's why we are doing the type of local content we are doing. But we did not rely purely on legal arguments. Again, we have to now look at our implementation model. And that's why our approach to the enforcement of the act is pragmatic. So we place a purposeful interpretation to various sections of the act. What do the lawmakers, what do they intend to achieve? How can we achieve it without disrupting the industry, without breaking Nigeria's obligations, international obligations? So those kind of attitudes guide the implementation of the act. There's another point he made, I think is the point about the scope of the board, that should be enlarged. Yeah, that's a fine point. All of us know in elementary law of agency that if an agent goes outside the scope of his mandate, everything he does becomes not only null and void, he will also be denounced by his principal. So that applies to government agencies. So every government agency that is established by an enactment, by a law, has clearly defined in those laws the scope of its mandate. So for us, the scope of our mandate is in the oil and gas industry for now, because Nigeria realizes that the oil and gas sector is pivotal. I mean, it's the mainstay of our economy. So in local content race, based on history and benchmark studies we have carried out, countries, when they apply local content, have to look at their low-hanging fruits. For us in Nigeria, the low-hanging fruit, where you get plenty of meat, is the oil and gas industry. So that's why we are starting with it. But it's gradually dawning on everyone that the success that has been recorded in the oil and gas industry in the last 12 years can actually be replicated to maximize the benefit of local content across other sectors. As I speak, there is a bill in the National Assembly seeking to expand the scope of local content to other critical sectors of the economy. That's a happy development. I pray it's successful, and then we see how it pans out. I can't remember some of the other points. He raised so many germane points, but if it's brought to my attention, maybe I will try to respond again. Thank you so much.
Thank you very much, Mr. Naboth. Are there any reactions from the audience? Any questions, contributions? Okay. So, my question will be to Mr. Naboth. Sorry, we seem to be bombarding you with questions. Okay, so when it comes to solving the energy problem in Africa, I believe collaboration is a very key factor. And underpinning that collaboration is lessons learned from other countries. So what would you say other countries are doing with regards to energy transition and local content? What lessons can we gain from them? That's one. Now, on the research and development part of things, we see a lot of the IOCs have their low carbon research centers in their home country, back in their home country. And we know that for as long as it remains so that the research is done abroad, we're going to have a serious problem. Now, have NCDMB, are there thoughts in the line of maybe trying to get the oil and gas players in Nigeria to actually domesticate research centers in country? Thank you.
Okay, thank you once more. On R&D, just as I hinted during my presentation, R&D is a critical enabler for local content development, and indeed for development generally speaking. Show me a country that is industrialized, and I will tell you that the country invests significantly in R&D. The paradox of the situation is Nigeria has earned so much from crude oil resources, but very little has been invested in R&D. No wonder we are where we are today. and begging for foreign direct investments that will disappear completely if care is not taken. Now, what is the board doing about R&D? First, we recognize, as the moderator said, nearly all the international service companies have their R&D centers offshore. They're all located overseas, and you can't force them. Before now, nobody could have compelled them. Their head offices will not even approve. And we understand the reason, because technology is the pride of a nation, and nobody will give you technology. You have to acquire it, if you can acquire, or steal it, as some nations like China have stolen, or develop your own. So you must figure out ways of stimulating technology transfer. So that's why if you go to the Act, there are sections on technology transfer, research and development, empowering the Honorable Minister to issue regulations that will be able to spur investors to think of transferring technology or promoting research and development activities in country. Now, the board has, even though the minister has issued regulations, in the oil and gas industry, and this is lesson learned, you are regulating global giants, and you have to be careful. You don't mandate anything. If you mandate, you lose it. That was part of the difficulty we were having with the PIB until more consultations had to happen. You consult extensively with them and get their buy-in. So in deploying our R&D model, all stakeholders now agree that, look, in the long run, domesticating some of the technologies will make business sense. And the regulation encourages that anybody who establishes their R&D centers here, there will be some fiscal incentives from government to reward those kind of acts. Because if you just legislate, the man withdraws, and you can do very little or nothing. That's why you see some businesses leaving Nigeria for Ghana and other places. So, but you have to find a way to attract them. And that's what our implementation model focuses. Next, the board had to establish a research council, an R&D council. Not just the typical government kind of councils. After inauguration, people take photographs and they leave. It's well populated by critical stakeholders that will make critical input. And these stakeholders are drawn from oil and gas operating companies and service companies with wide breadth of experiences, as well as members of the academia. In fact, our model is called Triple Helix. Triple Helix is that you should unite those critical stakeholders, the academia, government representatives, and the industry, so that everybody comes to a round table to agree on research focus, relevance of research. And for the academia, who have been doing research that is left on the shelf, that is meaningless, because those researches are just essentially to get promoted. They are taught that you have to do more of applied research. And it is only when you come out with a research that is relevant to the industry that you will benefit from the 50 million R&D fund set aside for the board. So one of the parameters for local content growth, we say, is funded. And you can see me linking each of the parameters each time I speak. So the board had to, 50 million is a paltry sum of money, very insignificant when you come into R&D, but it's a starting point. So what is NCDMB doing to ensure that this pool is extended? NCDMB is promoting collaboration across the country, across industry stakeholders, across the region, that to create the required infrastructure, to create the possibility of utilizing our hydrocarbon resources upon which we depend heavily. So countries need to also support so that we pool resources to catalyze research. So development finance institutions need to come in. Banks like Afreximbank, African Development Bank, and others. And that is part of the conversation that NCDMB has been promoting in the African Local Content Investment Forum. Now, the last question is on what are others doing regarding energy transition. Yeah, in my prelude, I made those things as early submissions. First, that energy transition sounds like a diatribe. It is a rhetoric originating from the EU, and the US. If you understand the history of what is panning out, you will know that it's part of their own survival strategy to reduce their reliance on energy sources that they do not have control over. So for America and Europe and others, that's what is happening. Ask yourself, why has China not given up its coal plants, or Australia, or even Germany? But everybody is talking about energy transition. So that's why I made a point that what has Africa contributed to energy carbon pollution globally? Less than 3% contribution. So the big polluters should be made to carry the can. So why are they dodging it and looking for people to follow? So they want to get away from fossil fuel, and they're encouraging their financial institutions not to fund fossil fuel projects, so that Africans will not have it. We will be left with no choice than to abandon our resources and move away. So that's why we need this collaboration, I mean, among us in Africa, and Apple needs to support NCDMB to lead the way. Because if we do not do it, we will be caught napping. And that will be terrible for Africa. Thank you so much.
Thank you very much. I've learned quite a lot, and I'll come to you for some more insights. Okay. So we would have some summary from each of the speakers, just about 2 minutes, to round off their point. And we'll start with Ms. Ene.
Thank you. It's been quite an insightful moment. If there's anything that I would speak on, is the fact that I think that it's important we talk about local content and its development in the industry. I just hope that as what we will do as regards regulation is to try and reduce the rigidity that we have in the legislations. Like I earlier said, if we want to sustain renewable energy, it means that we need to invite stakeholders for funding and investments. That means we need to reduce the rigidity that we have in our legislation, especially our taxation policies. So this would encourage participation across local content. And I do hope that stakeholders and local operators will be involving in Nigerians participating in this sector. Thank you.
Okay. I think I've spoken so many times in this panel session. Okay, so just to recap some of the points I made, my co-panelist is right that we must not take away our eyes from the ball, and the ball is local content, because it is important for our economic survival, as I keep saying. Fortunately, even subsequent legislations that have come after the Local Content Act have tended to entrench the importance of local content. And that's why if you read the PIA, it says that excluding the Local Content Act, all other laws in the oil and gas industry are subject to the PIA. So in other words, it elevates the local content law. And secondly, the same PIA makes local content one of the core 5 objectives of our energy policy and practice in Nigeria. In other words, trying to emphasize that we must not forget the importance of local content. You see it play out, even in provisions talking about for field development approval, that local content, Nigerian content plan is mandatory. So all these provisions in PIA tend to underscore the importance of local content. And local content we need to do so that can create jobs for our locals. We need to create opportunity for nationals. We need to also retain capital in our country. We need to grow the capacity of our own people so that they can play a role even in other countries of the world. And for energy transition, my point is the same, that energy transition is a reality, but Africa has huge hydrocarbon resources. We must not abandon our resources because of the noise all over the area. It will be like a man who hears that rain is about to fall and he throws away his water bottle. Thank you so much.
We have all agreed that local content is key in developing capacity for gas sector. We all know from all our discussions that capacity development to carry the gas to that national aspiration is very key. So local content board management, we need to fast track its collaboration with NGP for the state consultative forum that NGP is embarking on, so that the youth will be captured, the capacity will be developed, and will take care of our economy. Nigeria will surely develop. Thank you.
Thank you very much. Are there any parting words from Dr. Subai? Is this still on?
Yes.
Okay.
Thank
please.
you. Thank you for having me. Just to also say that we should look at externalizing the local content experience that the NCDMB has been able to garner and see how to integrate them to other relevant sectors. I am happy, as Mr. Nabot pointed out, that there's a bill for the National Assembly that seeks to entrench this idea. I want to believe it will see the light of day, and that the Nigerian local content policy will be sustained over time. Thank you once again for having me.
Thank you very much. It's been a very wonderful and a very engaging session. We can judge that from the time that is taken, and we've learned quite a lot. I think there's no gain saying that local content is an imperative for the survival of both the Nigerian energy industry and the African energy industry, and we must look to use what we have, which is readily gas, to get what we want, and ultimately looking at energy efficiency and not really moving from one fuel source to the other. So that's we've come to the end of this session, and thank you for my panelists and the audience and everyone that contributed. Thank you very much.
Ladies and gentlemen, I think we could do much better for that audit. That panel was... Thank you very much. That was a great thing. I find that generally, when you talk of local content, it is one thing that we underestimate, but some of the statistics that that Mr. Onyeso shared with us, I happen to have personal knowledge and can validate that local content has gone a long way. We are in a nation where we thrive a lot more on bad news and the negative. And I wish there was a way we could focus more on the positive. And I can tell you that we have made a lot of strides from the days when local content was just a single office in NNPC to what it is now. So once again, we say thank you very much for that. And now we'll be going on to our next panel discussion, which will be focusing on the benefits of ADR in, if I can paraphrase it this way, as we are looking towards this transition and wanting to get the best out of it. We know there are going to be lots of transactions, commercial and otherwise. There are going to be agreements. There are going to be relationships. And once you have those things involved, one thing is inevitable. There'll be disagreements, there'll be disputes, and there'll be conflicts. And those conflicts and disputes have to be resolved. Traditionally, the answer is to get your day in court. But these days, the courts remind me as though they speak in the same language as the Holy Scriptures used to speak. Going to court in Nigeria one day now is as 1,000 years, and 1,000 years as one day. So And in very many places, by the way, it's like that as well. What is the answer? We feel that using ADR would help in a long way to consolidate what the gains really are and what the gains really should be in moving us forward, both as a nation in Nigeria as well as in the African community. And this morning, to help us discuss that, as I said to the members of the panel when I met them outside, I do not patronize them, neither do I unduly exaggerate, but I believe that you could not have had a more eminently qualified group of persons to help us to go through this discussions. And so without wasting much more time, it is with the deepest respect and actually a sense of privilege to invite to come up and to be on the panel this morning. And they say is the year of the women, so I'm not going to start with the men. I'm going to start with my fair lady, Mrs. Olajumoke Delano, who is the Director of Legal Services, Abuja Electricity Distribution Company. You're welcome, ma'am. Please, I believe. Okay, there's been some changes now. Okay, great. Your choice, wherever. There are 4 seats, and you get to choose the best. Okay. I would also want to invite to join her right now YC Mikel, who is a senior advocate of Nigeria, as well as an arbitrator. Welcome, sir. I told him that we were looking for him yesterday to give us a good, to give us a goodwill message, but maybe he'll get to say something nice to us this morning before he makes his presentation. Also with them, I would like to invite a partner of Templars. Interestingly, before you come, wait now. You know, I actually feel a sense, why I said I feel a sense of privilege is that the 3 persons I'm going to be calling up now, I've had a relationship with them when I was at ExxonMobil, and Templars was one of the council we worked with. So it gives me great pleasure to invite Mr. Godwin Omaka, who is a CEDA accredited mediator, an arbitrator, and partner of Templars. Also, one whom I've known like forever also, professor. There are 2 professors here today. So you can see, better take your notebooks out. Dr. Bolan Elias of G. Elias & Co. He's an arbitrator, an excellent lawyer, and I say that without exaggeration. So you're welcome, sir, please. He's the founder and founding partner and managing partner of G. Elias & Co., a foremost company. And okay, no, we probably will need one more seat. No, what I was already going to say that actually on my own part.
I will sit by Prof. Prof, you come sit here.
I told you that you are in for a session this morning. Now you're getting a foretaste of it. And last but not the least, I did mention his name yet, but Yes, last but not the least, I want to mention someone who thought he would get away with it. And we also call him Prof in very many ways. He's a senior advocate of Nigeria. He's a partner of Aluko and Oyebode. And I have known him for very many years. You know, the first time we met was when we were doing that arbitration at the Lagos Center. And I was sitting next to him, and I remember there was one time when it seemed as if things were getting, he's a very humble person, very modest. At the time I had to tell him, look, assert yourself, don't let these people misread you. An excellent lawyer, excellent arbitrator, and I believe we're in for a good time today. So I want to welcome the panel. I think we've got a great panel here with us. And my name is Akisoya, Adeyemi Akisoya. I'll be moderating this session and also putting a few words in on mediation along with Godwin Omaka. But before we proceed now, I understand that there is a plaque presentation that is to be made to the last panel. So please bear with us 5 minutes while we do that presentation very quickly. Professor Elias, we have to make you do something. So will you please do us the honors of presenting these plaques?
Very happy to, sir. Although I was wondering whether I should protest since you exposed all of my secrets. I'm the only person that you say you have known since forever. That does everybody else.
The truth is, I know. Don't mind them. It's just interesting to know that you're dealing with people. Not only do you know them, but I'm telling you, I have personal knowledge of the fact that you could not have a better panel of persons to speak to you on ADR here today. So please get them. Outside of here, you will pay. Okay.
Do I need to come there?
I think they should come to you. Now, photographers, what do you prefer? I think you like that backdrop, isn't it? Okay. Can I please invite Dr. Mohammed Ibrahim? Is he here? Or his representative? MM Ibrahim? Okay, fine. As well.
Okay. Thank you. Thank you. Congrats.
It's not the name on it.
Who?
It's for CP1
Okay. Okay.
This one, could I have the representative of Mr. Simbi Wabote of NCDMB to please pick up the next plaque? The next one, engineer, Dr. Wisdom Enang. And last but not the least, for Oyetola Muyiwa Atoyebi, SAN, by his representative.
Very well done.
Thank you very much, Dr. Lars. Thank you very much. We're very grateful. Thank you, sir. Okay. So we'll go straight on into our our presentation. This morning, we're going to start with Mrs. Delano. It's the year of the women, so we'll always let them go first. So we will not be offended, and will not offend either. So I don't know, is your slide with them? Yes. Okay. So, ladies and gentlemen, I'd like to invite Mrs. Jumoke Delano to give her presentation. Let us give you a little hint. There are 2 presentations, and then we're going to have a general discussion among ourselves following the presentation. Do you want to take it from here? Yes. I understand this.
Good afternoon. Jumoke Delano. It's my pleasure, it's my privilege, to be here among such eminent persons on the panel and even in the audience. Thank you for the opportunity, to share, some of my experience with you and also to learn from all the wonderful people that are here. So today I'll be going through ADR as a tool to ease in the African energy transition, but I'll be focusing on the role of the Corporate Council, what happens within organizations, and how ADR has featured in discussions, within Abuja Electricity, which is a distribution company downstream on the power sector value chain. So that's the outline, but I'll make sure I don't repeat the things that have been said already so that we can make very good use of time. Of course, electricity and GDP. Electricity industry is one of the highest revenue earning industries globally. Even in developed nations, there is a lot of contribution of electricity, to the GDP of those countries. How much more in a country like Nigeria, where there is the energy deficit is huge. There is a lot of opportunity within the energy sector, to contribute to the gross domestic product of Nigeria. The other issue that is critical, since we're talking about energy transition, is the amount of money spent on diesel imports, the effect of those diesel imports on the carbon emissions, and how addressing these diesel imports by generating electricity using cleaner fuels will directly benefit Nigeria in terms of GDP and also contribute significantly to the reduction in emissions. There are 2 targets to be mindful of. I won't go into too much detail because it was already discussed. 2030, energy access for all. Are we prepared? 2030 is 8 years from now. 2060, net zero emissions. What steps is Nigeria taking in order to achieve these targets? In sub-Saharan Africa, as at I think 2019, they say 570 million people don't have access to electricity. In Nigeria, as at 2020, 90 million people are unserved. Now, this is a challenge, but it's also an opportunity. So it depends on what way you look at it. There is an opportunity to plug this energy access gap. We'll go straight into the structure of the Nigerian electricity supply industry, which is the NESI for short. In 2013, there was the privatization of within the Nigerian electricity supply industry, resulting in 6 generation companies being privatized and 11 distribution companies being privatized. The 11 distribution companies are set up currently such that 60% of the ownership of those companies is with the private sector, while 40% still remains with the government. So while it's interesting though that within the Nigerian electricity supply industry, while there has been privatization, the sector is still largely integrated. So it's in different hands, but it's very connected, and that's something that is very important to bear in mind when you talk about, you know, development of the energy sector with respect to electricity. This is just a diagram of the key stakeholders within the electricity sector. There are quite a number of players, but we're going to be focusing on a fewer number. This electricity value chain is important that you understand the electricity value chain, even from the perspective of a customer or a consumer that receives electricity supply, you know, from a distribution company. Many people still think that the distribution companies actually generate electricity. We don't. So, but we supply the electricity that we have received from generating companies to our customers. From one end of the value chain, you can see that the gas or fuel suppliers are on the extreme left towards the top. They supply the fuel to the generating companies, and this is wheeled by a transmission company of Nigeria to the distribution companies, who then supply customers. At the bottom, you can see a green arrow from right to left. That represents the energy flow. So for the amount of money that, you know, you are billed as a customer, this amount of money is shared among the players within the value chain, with the distribution companies keeping about 25%, transmission comprising the market operator, the regulator, the bulk trader keeping 15%, and the generation companies keeping 60%. So for every 1 naira that you pay a generation a distribution company, 60 kobo goes to the gencos, 15 kobo goes to transmission market operator, regulator, bulk trader, and 25% is kept by the distribution companies. Now, because of these relationships that exist across the value chain, there will be disputes. And I'm just going to go through very quickly the provisions of existing agreements. How has dispute resolution been handled in those agreements? The first one is with the regulator. That's the Nigeria Electricity Regulatory Commission. And, you know, the documents where you will find these dispute resolution provisions are the license terms and conditions. There is a one that is signed with every licensee of NERC. And then the EPSRA, that's the enabling legislation, Electric Power Sector Reform Act, and then within the business rules. Now, the dispute resolution provisions within the license terms allow for negotiation. So NERC has the powers to negotiate when there's a dispute between 2 licensees. On the subject of interpretation of the license terms and conditions, NERC's interpretation is supposed to be final. Now, that's an interesting one. But, you know, it's one of the provisions of that agreement. And then, you know, NERC is empowered to mediate and arbitrate disputes between licensees. Already you can see that in developing the documents, you know, for the power sector, there was already an understanding of the need to include ADR, which I'll call appropriate dispute resolution, you know, mechanisms within the documentation. Within the EPSRA, which is the enabling legislation, there are some provisions there, you know, for dispute resolution, and one of them is review. It's a bit problematic, this review in practice, because the way it works, if you get an adverse decision from your regulator, which you don't agree with, you can apply for that decision to be reviewed. However, it's unlikely that a regulator that has given you a decision before will overturn that decision. So that's one of the challenges with that provision. For questions of law with and other disputes with the regulator, those are referred to litigation. So that's one of the challenges we find with the dispute resolution provisions. For every dispute you have with your regulator, many times you don't want to sue because you'd rather manage that relationship. And, you know, litigation is very adversarial. Somebody is a winner, the other is a loser. And even if you come out of that relationship winning, have you really won in terms of, you know, what it portends, how does it portend for you as a licensee within that sector? So this is one of the concerns that we've had, that the only avenue for resolving disputes with the regulator is through litigation. And in terms of time, that is also a concern. How long will it take for that dispute to be resolved? I would like to say that there is a bill before the National Assembly. It's called the Electricity Bill, which is an attempt to, you know, make a comprehensive post-reform act, you know, that takes into consideration all the issues. And one of the things being proposed under that new law is, under that bill, is that there would be a dispute electricity appeal tribunal that can look into disputes that you have with your regulator, so that at least there's additional opportunity for dispute resolution under ADR. So that's in the works now. With respect to NBET and operational companies, NBET is the Nigerian bulk electricity trader. They are the bulk buyer. They buy electricity in bulk from the generating companies and they sell. So they are an intermediary between the distribution companies and the generation companies. The provisions within the agreements, we have a vesting contract. There's a vesting contract between the NBET and the distribution companies. And then there is a power purchase agreement between the generation companies and NBET. Within those agreements, the following are provided as alternate dispute resolution, you know, mechanisms or appropriate dispute resolution mechanisms. We have negotiation, arbitration, expert determination, and also interim relief through the courts in Nigeria. The interesting thing about expert determination, though, is that within the agreements, it was supposed to be within a particular threshold. But those documents, that information is missing. So whilst expert determination has been provided for under the agreements, but it was not the actual value that you can, you know, the threshold with which to refer a matter to expert determination was not provided. Now, with respect to arbitration, the rules, UNCITRAL rules of arbitration are applicable, and you know, where it's a dispute above $5 million, you'd have a 3-man arbitrator panel, and where it's one arbitrator, you have one arbitrator for disputes less than $5 million US. The location is the forum will be in London, England, and the laws, of course, are the laws of the Federal Republic of Nigeria. For the investor agreements, we have, I've given about 3 options there: the share sale agreements, shareholder agreements, and the executed performance agreements. These are the agreements signed This is a TCN. Okay, so these are the dispute resolution provisions for these 3 agreements. They were similar, and it's a graduated process, which is quite, it's almost like the norm now, starting with a discussion by authorized representatives of the company who are supposed to try and resolve the disputes before escalating it to external channels. From that discussion or negotiation, then you go to arbitration for matters that cannot be resolved. And then, of course, there's the provision for interim relief in the courts in Nigeria. The rules are the UNCITRAL arbitration rules, and the forum, the location is in London. For the system operator, the agreements between the distribution companies, operational companies, and TCN as system operator, the agreement here is the grid connection agreement. And the dispute resolution provisions are similar to what we've seen, you know, previously, either, you know, resolution by the parties. If that does not work, determination by experts. Then there's the provision for domestic arbitration and international arbitration, interim relief in the courts, and the rules are stated, there. So there is, if you go through the agreement, you will find out that there's quite a bit of acceptance of ADR for agreements that were created on or before 2013 when the privatization took place. For the market participation agreement, which is the agreement between the market operator, one of the companies under TCN, and the distribution companies, there was no specific provision in that, in that agreement. Now we come to financing, which is key when you are going, if you're talking about energy transition and funding new projects for electricity generation. For the acquisition facility agreements, the provisions here, actually, there is no ADR provision within the agreement. In the agreement that was available that I reviewed, it was the courts of England that, because probably, money debt, there was no ADR there. And of course, it will depend on the lender. What does the lender want? No ADR provisions were there. The laws were laws of England, and the location, of course, London. Recently, CBN has intervened in various ways in recognition of the tariff shortfall within the electricity sector to provide some capital. Because of the tariff shortfall, because of the extent of debt on the books of the distribution companies caused by the tariff shortfall, CBN, Central Bank of Nigeria, has intervened by providing various facilities, to assist the distribution companies address OPEX and CAPEX challenges, to address tariff shortfall requirements, and also to fund interface projects. You may have heard the discussions about, the distribution companies are rejecting load and they are not accepting power, because that's a dispute that has arisen because the distribution companies want the energy to be wheeled to particular places, but the transmission companies insisting on dumping the energy where the distribution companies don't want, the energy. So that's the origin of that dispute. In order to address that challenge, that's why you have that item 3, NEMS 3, DISCO plus TCN interface project. So these different funding initiatives by the Central Bank of Nigeria, have come into the sector in the last 2 years. But the dispute resolution provisions were for the courts, resolution by the courts of the Federal Republic of Nigeria. No ADR was provided within these agreements. Sorry, the national mass metering was also a part of those intervention programs. Now, the market rules governs relationships between sector market participants, licensees, where they have disputes. There are copious provisions for ADR within the market rules: negotiation, mediation, conciliation, arbitration. There is a dispute resolution panel, and the procedure for going about ADR is stated in the market rules. Interestingly, the dispute resolution panel has not been used, to the best of my knowledge. Although it's there, it's not been used. So that's quite problematic, because this would have enabled, the DISCOs or whoever was had disputes to resolve it. We are planning to take some issues before the dispute resolution panel, which we've not been able to resolve, through other means. The way forward. Disputes are unavoidable. Once you get into an agreement with someone, it's better you put a dispute resolution provision there. No matter how nice and interesting things seem when you sign the agreement, it's wise, to have a dispute resolution provision that addresses how disputes will be resolved. The interesting thing is there is a preference for the large, complex, transactions. There is a preference, sometimes for those disputes to be resolved through arbitration in international, locations that are neutral to the parties that are involved in the disputes. So often the dispute resolution clauses are progressive and can be escalated when the disputes cannot be resolved by the parties. ADR provisions should be agreed during the contracting process. Now, Africa's capacity to benefit equitably for its own resources is one of the challenges, because you have a dispute and then you take it to the UK. I remember there was a budding dispute between my organization and another government agency, and I was told, Jumoke, you know that this is in London, so that so that if this dispute takes place, that's where we're going to be. And you can imagine that it's quite expensive, very expensive. Even if the process is fast, but you have to fly somebody out, the person has to be resident there, until the dispute is resolved. Now, is it you can't blame the investors, foreign investors who have brought their funds in, because they are also concerned about the rule of law and sanctity of contracts, ensuring that the judicial systems, wherever they have chosen to resolve their disputes, will honor the terms of the contract. So you can't really, blame them. So these are some of the concerns why foreign investors may be concerned about submitting to arbitration panels in Africa. Some of them, they feel that within the local context, there may be politicization, that you can put pressure on the judge, you can lean on the judge. And I mean, it has happened before. I've had discussions with people who say, but we know the judge. And when you hear things like that, you're just like, you know the judge? What does that mean, you know the judge? So you know the judge, does that mean you can go around the back and, so it's really, horrific when you hear things like that. So that's one of the concerns that investors would have. Investors worry that a well-connected local player or state-affiliated entity may have an opportunity to exert pressure on the local government or court system, which could unfairly prejudice any pending or ongoing dispute. So the other aspect is the availability of facilities, arbitrators, and experts. Will they get visas? Part of the politicization of it. I've heard somebody threaten, a Nigerian threaten someone, say, I'll deport you from this country. And so this deportation, was it because he breached the immigration rules, or because your contract with him is not going as expected? So those are some of the challenges that in making Nigeria, Africa a destination for dispute resolution, we have to think about. So 2 recommendations basically here. Establishing local arbitration centers if we want there to be more resolution of disputes within the African continent. Establishing and building the credibility. So not just establishing, but building the credibility of those local arbitration centers. There are examples of those in Cairo, in Nigeria, also in Kigali, Casablanca, mediation and arbitration centers are already, examples of the venues that you can hold arbitrations. The other aspect in terms of recommendation is also the continuous professional development of local arbitrators to bring them up to date and ensure that they can, of course, handle any disputes, and there's no need, to have those disputes going abroad. Thank you very much.
Thank you very much, Mrs. Delano. One thing that I could not avoid noticing is that if you are going to be investing, already, as soon as we started putting emphasis on clean energy and all that stuff, the first thing that came across to us was a threat that those foreign investors are no longer going to be financing anything that is not compliant with the change energy. So of course we then have a little challenge. Can we look inwards and do it without them? Well, we don't have enough money, that's the truth. But what are the things that would make it attractive, make it easier for them? In the very brilliant presentation that the Learned Council from Abuja Electricity put out to us, three things. It is clear that there is uncertainty as to appropriate fora that can lead to a very quick and equitable resolution of disputes. That means it's either you're going to be influenced by politics or you're going to be delayed by time. And even where those factors are not present, one of the things that she's pointed out, and I believe that we really need to think about, is NERC has been there, ESPRA, all of those things have been there. And she's right. I happen, for example, personally to be a member of the dispute resolution panel of NERC. We are in our second 5-year term. We have not resolved one dispute. And that is true. And this is one of the things that we have to think about. It's not enough to put in place those facilities, but are we prepared? Do we have the will to make them work? But I'd like to stop there for the time being. Thank you very much for a very brilliant presentation. Next, I'd like to turn to Prof. Bola Elias to please bring up his presentation to us. ADR as a tool for easing this transition. And please welcome Dr. Elias. Thank you. Is that working? I think it works. Okay.
Hello. Yes, thank you. People, why is the thing not on the screen now? Mika. Well, before you come, okay. But I wanted to mention two things before we go forward. One is a point made towards the end of the presentation by Mrs. Delano about foreign investors in particular liking neutral venues. I think it may be even a little worse than she was telling us. I've had a recent experience of a foreign investor who was supposed to be a witness in arbitration here. And a bit different from what the papers were already on their face. When the trial part actually started, it became clear that some theory of fraudulent conspiracy by the foreign investor was being raised, and that they were, at least it was being insinuated that they had come here to steal money and they were fraudulent and the rest of it. And of course, the way he saw it is, if I come to Nigeria to testify, the moment I arrive at the airport, the FCC is going to carry me. So, end of story at that point. So whatever is necessary, I'm not coming. Just forget it. I'm not going to come because I see a big risk of that. So it's not just a fear of the system being manipulated, is also more physical. I can be locked up. And there have certainly been Nigerians in the past who thought they were doing a civil case, particularly against the federal government. And they ended up in Alagbon, at least for a few days. So that's a very, very material consideration. But thank you. If I may go on to, I know Tunde Fagbonlu has experience of somebody like that in the past. Second, let me now come to the subject of the presentation. ADR as a tool to easing the African energy transition. ADR is certainly a key tool to helping to ease the transition because, as my big brother Yemi Akinsa has said, there are going to be disputes along the way, and it will be important to resolve them if progress is going to be made. ADR is one of the ways of resolving these disputes, and therefore it has a key role to play. But we should bear in mind that it is limited in two ways. One is, one is that it is not comprehensive. All ADR methods, to a greater or lesser degree, involve some measure of consent by the parties who are using it. It is not like going to court where you can just force somebody else to come if you have a claim against them. There must be that basic element of consent in the beginning, and if that is absent, in particular, if there's no previous contractual relationship between the parties, and it is basically what we would call a dispute entirely about statutory duties or tort, then you may find that you can't even get into this kind of forum to resolve that kind of dispute. The second is that resolving disputes is only one way to make energy transition painless. There are many other things that are needed. For example, you need money to actually set up the new installations and so forth. And of course, you need to train people to become proficient in the new ways of generating energy. So short answer, ADR is an important and necessary tool for easing the transition, but it is definitely not enough because there's a lot outside it, both as to for resolving disputes and as to the other things that need to be done to make the transition possible. So let me also talk about a background elementary thing. What is this transition that we're talking about? The one thing that is clear about the transition is that it's a transition away from liquid petroleum. Beyond that, there are many dimensions to it. You may talk about a transition from liquid petroleum to gas. It could be from liquid petroleum to hydrogen, biofuels, renewable resources like solar and wind, and at the far end, nuclear, which at least to some people at first sight sounds even more extreme than petroleum. But the fact is, you don't really need much of the nuclear fuels to generate enormous amounts of power. So perhaps they're less of a threat to the resources of the world than is widely imagined. But at least I mention all of those to show that there are many different aspects of the transition. And when we're talking about Western world banks not being so keen to lend money, it actually depends on where you want to go with it. There are still many who will be happy to lend to gas, at least for the next decade or so. Gas is supposed to be relatively clean, so is hydrogen. The purely natural ones, solar, wind, hydro, there's less of a problem with that. Nuclear, you may still find some hesitation for reasons that at least to a technical engineer are more sentimental than anything else. But let's bear in mind there are many different aspects to the transition. And the transition in the near future from oil to gas, I think is in principle not as controversial perhaps as from oil to nuclear. Then we come to ADR. When we think of what exactly makes a dispute resolution method, ADR, there are at least two aspects of it to think about. One is how you even get to the forum in the first place. And as I've mentioned, there is an element of consent there that is typically associated with the idea. And if a method of dispute resolution is compulsory, then ordinarily we don't think about it as ADR. But we'll see in a minute that the terminology has got a bit confused and messed up. The second is about the enforcement. If you look at mediation, for example, at the end of mediation, the outcome is not really binding on the parties. The mediator will try and reach something that is palatable, fair and reasonable, and in many cases they will accept it. Certainly not always, and they are not legally bound to accept it, which is the point I want to emphasize here. On these 2 points, ADR differs from going to a court. You go to a court, you can be dragged to a court whether you've ever said you're interested in going there or not. And at the end of the day, the decision made by the judge is going to bind everybody. Both of those two issues, at the very least, have big question marks around them when you are talking about arbitration. Ordinarily, you can't be forced to go there if you don't want to. And if you go there and you try it and you don't like it, except for arbitration, which is a little different from, it's different from the other kinds of ADR in that respect. You're not necessarily bound by the outcome. Now, the difficulty here is what, with some of the other fora that we'll be thinking about. And I would like to isolate at least 3 of them in a fairly significant way. One is, or at least one set consists of what I call the regulator ADRs. I've always been very troubled by that concept, that a regulator can now tell those that it is regulating that if you have a dispute, either that you must arbitrate it with me, the arbitrator, as the registrar, the manager of the process, or at the end of the day, if you don't comply with the outcome, I can take away your license or some such thing. To me, I'm not sure that many of these things we are hearing about from NERC and more recently from the DPR, to me, they are not ADR at all. Although they may be given the name of arbitration or whatever else, that is not what they are, because you still have the force of government power behind them, and the parties are not free to avoid it. It's not really ADR. To some extent, you have the same problem with investment treaty arbitration. Under bilateral or multilateral or other investment treaties, ICSID, whatever, PCA, you can have essentially arbitration with the backing of the international community. And to a greater or lesser degree, those may be backed by sanctions. For example, ICSID arbitration, at the end of the day, ICSID has the World Bank behind it, and if a particular country doesn't comply with the outcome often enough, maybe you won't get any more money from the World Bank. That's there. But this issue of the level of consent that you need, and whether if that consent is diminished in a significant way, you're still talking about ADR, is there. To that extent, there is a question mark about whether we're really talking about ADR in these cases or not. In the case of a regulated entity having a dispute with the regulator, to me, it is absolutely not ADR in any shape or form. You can't even call it that. That is just government power being exercised against you, with you not having a way out. To me, it's just an administrative tribunal. It's an administrative dispute resolution. Maybe that's what ADR means in that context, rather than alternative. But it is very conceptually different from the other methods. And we also need to bear in mind, and I'm still waiting to see this happen, at some stage I believe somebody is going to sue these regulators as to whether what they are doing is trying to exercise a judicial power, which they are not entitled to do under the Constitution. Because if an agency, whether the DPR, NERC, or anybody else, NCC, whoever, although I think the NCC is probably less guilty than the others, but not entirely innocent. If you are saying that if 2 of you have a dispute, not only must you bring it before me, I'm also going to resolve it, and will be tied to you if you don't do what I want. That seems to me to be a judicial power, and I'm not at all sure that they are entitled to do so under the Constitution. The Constitution is very clear. The judicial powers of the Federation shall be vested in the courts, not in administrative tribunals. The moment you move away from simply saying that you as a regulator can make a decision against somebody that you regulate, and you're now saying that 2 people who you regulate have to come to you to resolve their disputes, and you are going to be the person to give them a binding resolution. That doesn't seem to me to be ADR at all. And it will be very interesting to see how this gets handled before by the courts if it becomes a constitutional law dispute issue. Having said all of those, the basic advantages of alternative dispute resolution over going to court are well known. Supposed to be fast, inexpensive. Both of them, I think, both of those points have become controversial because some arbitrations go on for a very long time. I inherited one many years ago that had gone on for 12 years before I came into it. And 8 years later, there were still little bits of it. Sorry? Yes. There are still little bits of it going on. Part of it is in the law reports. I know Tunde's people played a huge part in that arbitration as well. Sometimes you tell foreign colleagues or clients about it, they are totally horrified. How? But that's exactly what happened. And part of the problem, interestingly, was that after it had gone on for some years, the claimant had to run away from Nigeria because he was going to be locked up. So he ran away, yes, and it came to he went all the way to the Supreme Court because the government authority involved, the government party involved now said that the arbitrator was biased to have given an order that the evidence could be taken from abroad, that he should go abroad, take the evidence, and continue here. They said he was biased. That litigation alone went all the way to the Supreme Court over nearly a 10-year period. If it should happen today, it would probably take 15 years rather than 10. But that's where we are. Yeah, so speed and cost has become debatable. But I still think there's an advantage in arbitration in spite of the speed and the cost, and maybe the drawbacks are more exaggerated than we think. What I've been seeing happen increasingly, and I would like my fellow panelists please to speak to this when they're on this podium, is that increasingly, if the dispute is fairly large and you want a resolution on the merits, the only way to get it is in arbitration. You won't get it in a court because you will keep wrangling over procedural posturing for many, many years. And serious businessmen are not really interested in that. Virtually, I think if I've done, say, 10 trials examining witnesses in the last 2-3 years, all of them, except 1 or 2, have been in arbitrations. You actually get to examine the witnesses, they give the evidence, you cross them, the tribunal hears you on the merits, reaches a decision on the merits. It is very difficult to get those things in court these days because somebody will just appeal on some interlocutory matter, and that's what you'll be dealing with for the next 5 years. Maybe at some stage your client will surrender out of frustration and say that they're no longer interested. But if you argue something through to the end and they can actually see a neutral person who has some expertise, familiarity with the issues, reach a decision on the merits, yes, maybe somebody will still challenge it in court afterwards, but I think that is less work than having to get a position on the merits only after 5 years of running around and not really knowing where you're going. So I think the issues of speed and cost, maybe they are a little exaggerated, but they are certainly there. And also in the nature of things, if the dispute is big enough, you are going to spend money, whether it's arbitration or litigation. You are going to spend serious money. All the fat cats on the stage are expensive people. And if you want your case done right, you probably have to. I'm not on the stage. You probably have to give them a few dollars, and not just enough to pay for their next vacation. It has to go far beyond that. ADR also has a big advantage of confidentiality. Things are done with some privacy. Nobody, at least in principle, gets too badly embarrassed, or so badly embarrassed that they are not willing to talk to the other side in future, or not willing to discuss settling the issues, even after the outcome of the arbitration. I'm sure that we'll hear many more about these and other advantages, but the key messages I would like to repeat are that yes, ADR is critical for the transition, although it's certainly not the only critical element. There's some controversy, differences of views as to what exactly the transition is. And absolutely, I also believe, third, that there is a big issue as to what exactly ADR is in this context, where you have the government in the background totally determined to bully private parties in disputes between two private parties. That doesn't sound like ADR to me, although it may have that label. Thank you very much.
Thank you very much, Prof. I believe one of the major things that we're hearing so far this morning is that ADR is critical to the transition. However, we're also hearing a lot of the limitations in the ADR, which I believe in terms of the outcome of such a conference like this, one of the things we'll be thinking about is, if we are thinking this way, then those who are looking at us from the outside are seeing the same or more. And that means, are they encouraged or discouraged? I think the verdict will be that if not discouraged, certainly they are not encouraged. So I believe that one of the takeaways from a conference like this is, what do we need to do to ensure that that hurdle is removed? One important hurdle which never ceases to amaze me is the fact that people tell me of arbitrations for 10 years, 5 years. I remembered I was in a program with Tunde Fabolu, SAN, some time ago, and I was still just saying very, very nicely, I felt very good with myself that, oh, I knew an arbitration that had been going on for 5 years, and I thought I was making a clever statement. And he turned around to me and said, oh no, he knows one that has been going on for 10 years. And now I've heard this morning now of 12 years. So we know that there are these little hurdles there that need to be crossed if we're going to ensure that people are interested. One other critical issue that Prof brought up, which I think is important, is the issue of being a judge in your own court, where the regulators are setting up ADR bodies. Can they really be relied on as sufficiently neutral and dependable for given neutral outcomes? And that's a question that I think we need to be examining as we go forward. And on that, I'll just pause there, and I'll say once again, thank you, Prof, for opening our minds to these things. As we go forward, we have 3 other panelists with us here, and I'm going to be inviting them one after the other to please make and bring their interventions to this. Now, if you notice, when Mrs. Delano spoke, she had a bit of focus on arbitration. Prof's focus was a lot on arbitration as well. I have some issues with you on mediation, which I'll bring up later. But I think at this point, just to create a bit of balance, I would like to bring on Godwin Amwaka to please bring his comments or his presentation on this with, I'll say at this point, perhaps in response to them, because I believe that they fairly covered the ground. So since we have had that pattern so far, can I trouble you to come here? Please. I'm sorry about that, but I think it just keeps the consistency. Aha. Okay, thank you very much. You can use this.
Good afternoon, everyone. And thank you. It's an honor to be here and to be part of this conference that has been put together by Rakiba and her team. Kudos to you. You've done excellently well. Now, I mean, the topic the topic for discussion has been spoken to by both Professor Elias and Mrs. Olajumoke. But I just have a few comments to make regarding the transition and how do we situate dispute resolution in the process. And my focus will be what role, if any, will mediation play in this transition? How do we situate mediation? How do we see it? Before I go into my comments, let me just pick up on a theme that Prof spoke to when he was talking about the non-binding nature of mediation. Yes, to a certain extent, I see it differently. Mediation is an inherently flexible process, and when parties agree to mediate their dispute, ultimately they agree to be bound by the outcome of the settlement agreement. And what we have seen lately is that those settlement agreements, unlike before, where you can only enforce them by an action in court. These days, as part of the legal framework and part of the incorporation of ADR into our judicial process, the award, once the settlement agreement is concluded between the parties, it is endorsed, for instance, under the Lagos State High Court rules by the ADR track judge, and it becomes immediately enforceable as a judgment of the Lagos State High Court. And I think there are other states in Nigeria that have similar provisions. And so, I mean, that's, yes, about 60% of the states have similar provisions. And that's the inherent appeal of mediation. The fact that, unlike with arbitration, which has become really judicialized to a certain extent. We all are arbitration practitioners. And what do I mean by judicialization of arbitration? It simply means that it's become too rules-based. And then, of course, many a times we get to see challenges arising from the process. Prof spoke about interlocutory appeals arising from litigation. I have seen a lot arising from arbitration as well. I mean, it's difficult to, and that's why, to a certain extent, arbitration, in terms of, like Prof rightly mentioned, in terms of time and speed, has lost some of its appeal. But nonetheless, it's still an effective and dispute resolution mechanism way and above litigation. Way and above litigation, certainly. So mediation, like I said, it's very flexible. The settlement agreements can be enforced by the courts, and over time, there are statistics that shows that 85% of the settlement agreements that result from mediation are respected and enforced by the parties. Don't forget, this is a party-driven process. It is the parties who drive the process. So, but in terms of energy transition, how does it work? And how do we place it? We are beginning to see, as this discussion started from yesterday, the transformation from fossil fuels to renewable sources of energy, and of course the talk about decarbonization. But one interesting thing as we approach cleaner sources of energy is the fact that dispute will always arise between stakeholders, between counterparties. And a few years ago, in Lagos, I was party, and I think your law firm was part of that transaction as well, where the first green building in Lagos, a high-rise building in Lagos, to the value of about $55 billion at the time, there was a dispute over it. Ultimately, that dispute was resolved by mediation. So we're going to see an increased role for mediation in the dispute resolution space as this transition goes forward. We've seen how mediation has gained wide acceptance and popularity over the past 2 years, arising largely from the disruptions caused by the COVID-19 pandemic, and the fact that the Singapore Convention on mediation has sort of, again, like the New York Convention, given mediation, international mediations arising from international agreements, the sort of enforceability and recognition you will typically have with an arbitral award. So that's an appeal. And when you see stakeholders, shareholders, counterparties, disputes resolving as a result of the transition, because as a result of the transition, what we are going to be seeing is we're going to be seeing investors coming in. We're going to be seeing investors exiting. We're already beginning to see investors exiting our energy space, and their position is beginning to be taken by some local players, and of course the Asians are coming in as well. And all of this creates room for disputes. We're going to be seeing a lot of disputes. We're already seeing them arising, typical disputes arising from JV, joint venture agreements. You're going to see disputes arising from shareholders agreement as well. Then one interesting development lately is the passage of the PIA, which again has completely redefined, at least for Nigeria, the legal landscape. While other countries are transitioning into hydro, geothermal, and what have you. What the PIA has done for us is to sort of move the emphasis from hydrocarbon to gas. And so, in terms of renewable for Nigeria, the focus to a large extent based on what we see from the from the PIA is gas. And again, one area of disputes you are going to be looking at is gas pricing disputes that's going to be arising as a result of the increasing use of the PIA and all of that. So that's one avenue where we see mediation likely to come in and play a role. I'll round up with a short story. I think what last year, the General Counsel of one of the IOCs in Nigeria, they had a dispute. And of course, like Mrs. Olajumoke was showing, the dispute had an arbitration clause. The seat, London. Of course, like she will rightly say, the law governing the underlying contract, Nigerian law. And we were instructed to, with International Council, to represent them. And in the course of one of our conversations, she said to me, Godwin, how we wish we can resolve this dispute. If this dispute progresses to arbitration, it's going to cost us a lot. It's going to hurt our relationship. We're in bed, and we want to remain in bed together, all right? And I said to her, have you heard of the word mediation? She said, of course, but I don't see how it's going to work in this case. I say, if you guys agree, why don't we pack the arbitration clause to one side? Let's suspend it and let's mediate. Of course, it will take your counterparty to consent to that process. And luckily, the counterparty consented. We appointed a mediator with one of the foremost commercial arbitrators in the country, a renowned ADR practitioner. And believe me, in less than 3 months, that dispute was resolved. And since then, what I have seen is every time they are going to get into an agreement, they send to us a dispute resolution clause that is multi-tiered. So amicable resolution, mediation, and then arbitration. So in King's Legal, we're going to see that mediation will gain more ground and more space. So also expert determination is going to be very critical for resolving disputes that are arising as a result of the transition. We've seen that play out for expert determination. We've seen a lot of it play out in Spain and Germany in 2008 as a result of the global meltdown, where there were serious issues about subsidies and incentives that were given to investors who invested in certain green technologies. And all of those things we are taking up. But those issues were ultimately sent to experts, and they were resolved quickly. I mean, expert determination combines all the advantages of ADR as we know them, speed, efficiency, and all of that. But one advantage it has, I think, with mediation over the other type is that the finding or the decision of the expert determiner binds the parties, and it is not subject to litigation or appeal. So it's a very appealing process, and I'm aware that ICC MENA is actually holding a conference next month, and they have a full session on, the role of expert determination in resolving disputes in the energy sector as we see it. So it's gaining a lot of ground. I think it's one thing that we are going to be seeing again, because a lot of these issues, some of the disputes that will arise typically from some of these agreements are highly technical disputes that will require people with certain skill sets to be able to resolve those disputes, who understand them. for instance, if you want to draw parallels, you may want to say the same thing of the construction industry when they talk about arbitration and all of that, and resolution of disputes via dispute boards and all of that. So we're going to see that with expert determination. At a personal level, I've been involved in this year alone, I've been involved in about 5. And only yesterday, I got a new instruction. Pardon? So only yesterday, I got a new instruction. So the idea is we need to situate ourselves, in all of those spaces to be able to take advantage and to understand that, yes, like Prof rightly noted, arbitration will be used for the really very large disputes. And as Mrs. Delano noted, especially in the power sector, you find out that a lot of the dispute relation clauses relating to having expert determination have a certain value to them. And many cases you find $5 million, $10 million, this sort of claims. So I think this is what we are going to be seeing as we transit into more forms of renewable energy. Thank you very much. Thank you.
Thank you very much. Thank you very much, Godwin. I like the answers he provided to some of the things that Prof had raised, and that is that mediation is not as loose as we think it is. I think sometimes it's a matter of the fact that we're not as familiar with it. And some of the experiences he spoke about are things that resonate with me. So I think the key thing that we are getting away from here now is certainly that if we are going to have an effective transition in this sector, one thing is vital, or rather 2 things are vital. Number 1, financing. Number 2, cost. That is protection because you need the financing for the foreign and other investors. And incidentally, although we always think of protection for the foreign direct investor, actually some of the local investors face some of the same difficulties. And I believe that one of the things that we're coming away from here is that, look, those kinks that exist, and they've been put out, definition, reliability, a measure of enforceability, a measure of applicability, and so on and so forth, are things that can be addressed. And in the past 3 presentations, we can see that those things, if they are addressed, will go a long way to improve the environment in which we are operating. So I'll say this, that our conclusion so far, ADR is certainly a useful tool. It would be even more useful if some of the impediments can be corrected. From the last speaker, we see that they can be corrected, and already with respect to, say, mediation, it is going on. The advantage of mediation is its flexibility and its ability not to be bogged down by technicality. What people used to be worried about is, can I enforce extraterritorially? And Godwin did point out to us that the Singapore Convention has taken care of that. So now we have full extraterritorial enforceability of mediation in commercial transactions. So one more thing has been removed, and there's speed, there's reduced complications of processes. So thank you once again, Godwin, and we're going to go on now, and I'm going to invite at this time, well, we call him Prof too, actually. But it's my very good friend, my learned brother, senior advocate of Nigeria, Tunde Fagbonlu. Careful.
Okay. Thank you, Mr. Akisoya. And I want to say thank you to all the panelists who have spoken before me. Good afternoon, ladies and gentlemen. I was almost thinking that I would speak last and therefore only going to be giving a vote of thanks. But I think that now falls to my very esteemed senior colleague, Mr. Mekiao. Okay. Of course, one of the problems with being a penultimate speaker is that everybody has practically said everything that I would have wanted to say. So, but I will still share a few thoughts. Let me start with a point that Godwin Omarka made, and that's about international investment arbitration. Yes, that's something which I think is going to be, we need to keep a very good eye on. Energy transition means that African countries are going to be investing a lot in attracting, investors are going to be looking to get a place within various African countries to establish photovoltaic plants, wind, solar, and all whatnot. These are very heavy projects that require a huge amount of funding. But more importantly, before they make those decisions, they would be interested in knowing what protection exists. And they'll be looking to bilateral investment treaties. Now, for now, as far as Africa is concerned, I think one feature of the bilateral investment landscape is that there are actually more bilateral investment treaties between African countries and non-African countries than there are between African countries and African countries. We are looking to the, hopefully, the second round of negotiations at the Africa Continental Free Trade Agreement to produce an investment protocol that will then fill that gap. In the meantime, we've started seeing some African country to African country BITs, like the Nigeria-Morocco BIT, which contain very interesting features that have not existed in your traditional BITs before now. Now, why are BITs important? BITs are important because this is the chapter 4 for investors. When I say chapter 4, I'm talking of fundamental human rights in our constitution. This is the equivalent of chapter 4 for investors. This is what contains all their rights, right? Fair and equitable treatment, most favored nation, national treatment, the umbrella clause, legitimate expectation. That's where it's all contained. So an investor is important to know that their fundamental rights are protected, and they'll be looking to see what the BITs contain. Now, luckily for now, like I said, many African countries have BITs with the places where you'll be expecting these investments to be coming from: North Africa, North America, maybe South America to some extent, Asia. While some African countries are beginning to jettison their traditional BITs, because of course we all know how controversial those BITs have become in terms of how they hamper states in terms of their regulatory capacity. The fact is that many of those BITs are still very much in existence, and even when they come to an end, because I think the solution for most African countries will be when they come to an end, don't renew them. But there's still what you call a sunset clause that allows those BITs to continue to regulate your relationship. For new investments coming in, the sunset clause may not be relevant. But I think what's important is that many of those BITs contain your standard, protections that investors love so much, particularly fair and equitable treatment. So there shouldn't be much of a problem in terms of those traditional BITs from the investor's perspective. But when you look at what we are likely to be expecting in relation to the negotiations going on right now at the AFCFTA for an investment code, to the extent that many people are speculating right now that that investment code is going to be based on what you currently know as the Pan-African Investment Code, which is a template investment treaty, you would see that a number of those traditional protections that investors like a lot, like fair and equitable treatment, have been dropped. Some other features include things like most favored nation and national treatment will not be applied at the pre-investment stage, but only at the post-investment stage. These are things that investors are not likely to find very palatable. So, while we recognize that we must strike a good balance between ensuring that the states can continue to regulate without much hindrance on the one hand, and on the other hand, ensuring that investors have comfort when they are making that investment decision, these are issues that we need to keep a close eye on as Africa negotiates an investment protocol under the Africa Continental Free Trade Agreement. So that's on, I mean, the only other thing I'd want to mention here, if you want to have an idea of why these issues are very relevant, just look at, and I think Godwin mentioned this, all the investor-state dispute settlement cases that have been going on between investors and countries like Spain, the Czech Republic, and I think Italy. They're all well reported, and you would see there have been disputes, like you said, over things like incentives, and there are going to be incentives. You know, when Nigeria begins to take very seriously inviting investors in to invest in solar and wind and all of those other things, there will be incentives. We saw those incentives when we were trying to migrate from JVs to production sharing contracts. And we saw what became of all those incentives and the amount of arbitration that has generated. When government now felt comfortable that, okay, fine, we've got all this money from these investors. We don't need to protect them this much anymore. And government now began to resile on some of those promises. So we've seen that happen in that context. There's no reason to expect it won't happen again this time around. And it's going to be very important at that point, what those BITs contain, or what your investment protocol contains. So that's all I'm going to say on international investment, investor-state dispute settlement. The other thing I would then quickly turn to is commercial arbitration. And Mrs. Delano identified situations where commercial arbitration will be happening as part of this energy transition process. She talked about, I mean, in the context of what we currently see, that we currently know, power purchase agreements, share sale agreements, finance agreements. Ms. Delano referred to all of those. Those are examples of the types of commercial arbitration you are going to be seeing. The only perspective, and I think it's been trashed by the previous speakers, the only perspective I want to bring to that question is this. I mean, we all know that that Africa has lovely arbitral institutions that use very modern rules based on UNCITRAL. We've even updated some of them to take account of technology and all of those things. So that's good. There is a good framework. We need to reform court support for the arbitral process. One of the reasons why arbitration drags on for too long right now, and some of the previous speakers have spoken about that, is because the courts, we still can't get to that point where we can say confidently the courts will not intervene in a way that is detrimental to arbitration. We still haven't got to that. We still experience it. I am currently doing a case in which a federal high court judge granted an injunction to stop a consortium of lenders from enforcing a finance agreement in relation to an acquisition of an oil and gas asset, notwithstanding that there was an arbitration agreement in the financing documents, right? And so when investors, financiers look at things like that, what do they think about? So, and these were situations in which the arbitration clause, in fact, was a foreign arbitration clause. It was for an arbitration in London. We saw how the Court of Appeal granted an injunction against an ICC arbitration in Cresta and Shell, right? So we really can't still pat ourselves on the back and say our courts are that friendly to arbitration. And when, of course, when those things happen, it throws questions as to what the efficacy of arbitration is within our domestic context. So we need to reform that system. But let's be careful. I think sometimes we over-exaggerate the extent to which what the problems we have with our ADR system actually has any impact on the investment decision. I represent lots of investors, and I know it's not your ADR system that drives them. It's the money. It's the money, plain and simple. People are very willing to ignore certain things when there's a huge amount of money on the table to be made, right? So the first motivation always is the money, okay? If the transaction is huge, if there are huge profits to be made, they are willing to overlook certain things. And why are they willing to do so? Because no matter what your courts are doing, right, they still have the option to choose a foreign jurisdiction. And in fact, a lot of the agreements that cross my table are agreements where investors are insisting on foreign jurisdiction clauses, whether it's a foreign court or it's a foreign arbitral panel. They are insisting on that. That's the way they get around the problems we have with our court system. That's the way they get around it. So who suffers? It's not the investors. It's we the lawyers, right? This is a lot of work that we could be doing, but once London is chosen and English law is chosen, and that happens in so many of these agreements, then you don't get to do that work. Notwithstanding that the transaction arises from Africa here or from Nigeria here. Okay? So that's it. There are only two exceptions I will identify where even when they choose London or they choose Paris or wherever else, our system can still negatively impact them. I've spoken about one of them already, the predilection of our judges to grant injunctions restraining foreign arbitration. So that is there, that's a problem. And that's one reason why investors may be they may pause before coming to invest in your country, in our country. The other reason is, and it's a point that I think that both Mr. Akisanya and I think Godwin talked about just now, and this is our military mentality. You know, this mentality of thinking that we can decree everything. So when a regulator sets up a new scheme, they also make themselves the arbiters in that kind of, under that scheme, right? In fact, so we've seen that happen in so many contexts. We've seen DPR set up its own mediation center. We've seen, I think Ms. Delano referred to one in the context of exactly the Regulatory Commission for Electricity. Now, there's even a more ominous one, and that is an effort that we heard about starting about a year or 2 years ago to enact some kind of arbitration policy that means that people are compelled, even if you're a foreigner, even if it's a foreign transaction, compelled to arbitrate that transaction in Nigeria, right? And there's been so much talk. I think they even came up with some kind of bill. They came up with a policy document, and I think they came up with some kind of bill to try to put that into effect. That's a very dangerous thing to do. That's the kind of thing that's going to make investors look at your economy and say, no, we can't invest. If we don't have that choice of our foreign jurisdictions, then there's no point in investing in that economy. So these are the exceptions. These are the aspects that could have an impact on that investment decision. We should not legislate by decree that people should resolve their disputes in Nigeria. Rather, what we should do is improve our systems and also improve our capacity. Energy transition is going to mean that professionals need to acquire a huge amount of expertise. You know, I keep on telling people arbitration is a process, but what makes a good arbitrator is not familiarity with that process. That is a given. It is assumed that you have that already. What makes you stand out is your knowledge of niche areas. So I commend the lawyers in energy because this is a good effort to focus the minds of lawyers who are interested on this aspect of specialization that has become very topical at this time. At LASIAC, on whose board I was until up till December last year, we've created an Africa Energy Arbitrators Forum as part of contributing towards this process of ensuring that those skills, you know, we need to create those skill sets. It's very important. In the substantive areas, your knowledge of arbitration is a given as a process. But what is very important is your knowledge of the substantive areas that are going to be very relevant in energy transition, whether it is renewables, whether it is oil and gas, whether it is technology, because again, technological disputes will arise, intellectual property disputes, given the fact that energy transition requires the use of very, very innovative inventions. So many areas of substantive law are involved in energy transition, and it will be very important that Nigerian lawyers acquire those skills. So with those few words, I say thank you again for the organizers for inviting me. Thank you very much.
I'm not going to try to summarize much, but there's one thing that I could not help noticing, which is lawyers, we have an opportunity that we should not miss. And it's not just a matter of taking these things from an academic perspective, but we also realize that if this thing is not addressed, it also means we don't have work. And when we don't have work, there's never a vacuum. Whatever work we don't do, someone else is doing it, so they're chopping it. So I think that's a very important takeaway. One other thing that I want to point out, and I thought Godwin was going to mention it, is that this idea of judicial intervention is not limited to arbitration. It's beginning to creep into mediation too. About 2 years ago, there was a matter in Singapore in which there was an application before the court to set aside a mediation settlement agreement on the basis of non-est factum. Yes, and in times when I have been teaching on mediation to mediators to be, or even present mediators, I've been saying to them, you must be careful, because one very important element in mediation is that the mediator must never become an adjudicator, must never become a judge or an arbitrator in the matter, and that the power of resolution must always be in the parties and visibly so that it cannot be questioned in a court of law. So thank you very much. One other thing which Professor Fagbonlu, I like to call him Prof. quote, which he pointed out, which I think is important for us, is that the investment will come if the environment is right. If the environment is not right, and why do we make it right? I believe again that as lawyers we have what I would call a lobbying role to play. We need to begin to influence our clients, we need to influence ourselves in our niche areas, know what we do, and then wherever possible we need to ensure that these things are put in place, because they have two benefits. Number one, the foreign investors and other investors, not just the foreign investors, will be encouraged to invest, and therefore will help the energy transactions. But more important still, not only the foreign investors benefit, but you and I also benefit, because we are building up a new market for ourselves. We have two more speakers this afternoon, and I'm going to call my learned silk, my Michael SAN, to speak now, but I also understand that waiting to speak to us online is Mr. Dr. Bayo Adaralegbe of Babalaki & Co. So he's going to come on with us virtually, but for now we'll take my learned silk.
Thank you very much. Again, I appreciate the privilege of being invited to speak at this conference. If Prof. Tunde came here and said what he said as the penultimate speaker, you can imagine what my position is, having to speak after him. Now, we are pretty much in agreement that ADR is a very important tool in easing African energy transition. And because I really haven't got any much to say, because all the speakers have spoken, maybe I'll begin to share with you what we are also doing in my state in terms of energy transition. Very interesting. Now, in my local government, we have about 40,000 hectares of land that has been cultivated with cassava. And the state, by the way, I'm from Kebbi State, and the state has entered into a partnership with... Pardon? I was just letting them know that the state is not... It's not in the United States of America. It's here in Nigeria. We've entered into a partnership with the NNPC for the production of ethanol from cassava. And only 3 weeks ago, I missed the opportunity of going to India to inspect the plant. In another 4 months from now, we expect that that plant would be installed in Kebbi, right there in my local government. So there couldn't have been a better opportunity to begin to prepare myself for the investment that is coming into Kebbi than having the privilege of being a part of this conference. And I thank you. I also invite you to come and invest in Kebbi. Prof, I know we rarely see you guys in court. And now I'm beginning to find out the secret, because you make very rare appearances in court only because of those parts of the court system that you require to secure the things that you do in the practice. So ADR is something that we've all agreed that is an important tool for this transition. And almost all the speakers have talked about the importance of ADR, and I probably repeat them within the limits or the limitations that have been talked about by the previous speakers. It's an informal process, it's consensual. So much has been said about that, because in arbitration particularly, it is for you to choose who your arbitrator is. You confer the jurisdiction on the arbitrator. Otherwise, whatever the arbitrator does, if he does or says anything outside of what you have given him the power to decide, that also can be set aside. And then it's a process that ensures that all the parties would be given fair and equal opportunity to be heard. There is direct communication between the disputants. You sit in the room, and sometimes even when you have lawyers representing you, there is what you call hot tub. Exactly. So you get the disputants to sit down, and even some of the things that the egos of the lawyers would not let happen in the course of dealing with those matters, by the time you bring the parties in the room to talk to themselves, you discover that those issues that you thought were unsurmountable are issues that the parties themselves would spend no time in dealing with. And you know, it's widely accepted outcomes. All those have been spoken about, and the preservation of relationships. It's difficult for you to go to court with someone, and after spending 15 years with that person in court, and still come back and have a relationship with that person. I don't think that it's ever possible. If you are able to do that, then you must be enjoying special grace of God, and I would commend that you continue to do that, because it's also good for you to be forgiven as you relate with your business partners. There is also non-interference with the projects. Compared to litigation, you can't be, the first thing you would do if you get into litigation arising from any transaction is to try to cause the other party, put him in some sort of distress. You know, because if you do that, then either you are forcing the party to come and negotiate with you, and at that point, really, the interest of the project is no longer at heart. The interest of the project is no longer at heart. So you don't care whatever you can do to mess with the entire project, even the benefits that you thought would accrue to the people, you know, and I say this even for government that have that social responsibility to people, to the citizens. You know, they take certain steps, not minding the fact that they had previously in the conception of this contract conceptualized all the benefits that will come to the citizens. Now, that is what litigation does. Now, do we just go along with litigation, I mean with ADR, without the requirement for the courts, for the national courts? The national courts would always come handy even in your deployment of ADR mechanisms for the settlement of disputes. There are times when you want the subject matter of the dispute be preserved. You have to quickly go to court for some interim interventions, you know, so that by the time you begin the process of giving notice of arbitration or any form of the ADR that you have chosen to deploy in settling your dispute, the subject matter would not be dissipated. So you need the courts. And now this brings me to the attitude of the courts in this country. Someone, I think, was it Delano that talked about, do you know the judge? And so you are asked that question, but sometimes we also hear clients asking us if you know the judge as a requirement for eligibility to be briefed. Well, it would have been laughable if it weren't pathetic. Because number one is an insult to the counsel for a client to think that your eligibility to actually be part of the case for him to represent him depends on whether you know the judge or not. And that is because over time, we have come to miss number one, and this might be an indictment on all of us lawyers. And when I talk about lawyers, I'm not limiting it to those members of the bar. I also include members of the bench. That is what I think, or what I have characterized as the lost ideal of the legal practitioner, such that what motivates us is different from what actually represents our principal and primary responsibility to justice. We have been we find ourselves being motivated by what we would make on the case rather than concentrate on the justice of that matter, which is actually our principal calling. Because we are agents to justice. Justice is a person, and we are simply agents of that person called justice, and whatever we have to do within the set limits of the law for us to attain what we agree is justice, that is what we are expected to do. But by the time we begin to get motivated by other factors, it could be ethnic factors, it could be religious factors. Of course, the money factor is actually the one that is more pronounced. Now, once the motivation for what you do in a matter is the money that you get, then you have missed the point. You are actually operating far below who you are as a lawyer, and that is why we have allowed this situation to fester in this country, not minding our principal responsibility, primary responsibility as socio-economic agents in the nation. Now, it is so with the judges, and that is why it's difficult for us to come up with judicial policies that would aid the economy of the country. The reason why London is what it is because whether it is written down or not, I know Professor knows this very well, and of course all of you here, because I have an idea of the level at which you practice now, having sat with you on this panel and having asked a few questions. Of course, Prof, we are in some matters with him as well, and I know the level at which he practices, so you are very familiar with what obtains in these foreign jurisdictions, and you know that these foreign jurisdictions decided to operate their courts with the consciousness of the fact that whatever they do impacts on the economy of the nation. So London is what it is. Singapore is also what it is today because they decided that they will come up with judicial policies that would by itself activate the economy and invite investors into the economy. Now we are failing to do that because we are wrongly motivated in the things we do, both as lawyers from the bar and as lawyers sitting on the bench. And so if we are talking about reforms, this is where to start. And almost like commending Romans chapter 12, talking about not to be conformed with the present status, but renew our minds, by looking at the things that we ought to do, find out who we are, who and what we should be doing in order to make sure that we see that which is good and acceptable and perfect will of the economy of this nation. So that is what we must do. That's the kind of transformation that we'll be looking at if only this transition that we want to see becomes beneficial not only to the citizens of this country or the entire Africa, and also to us as lawyers. And I thank Prof for that perspective that he brought about the fact that even the investors are motivated by what they get. Sometimes in maybe around 2018, 2016, 2018, the volume of foreign direct investment that came into this country in spite of the insecurity caused by Boko Haram and the rest was mind-blowing. You would have thought that with the sort of insecurity that was in the country, that foreigners would stop coming here But that was when we had even more foreign direct investment in the country. So the question is, what is motivating them? And I believe that supports what Prof said. And that is why, for some of us who were here yesterday, you saw the maps, I mean the slides that were shared, that were shared. And you would see that if you were to put the globe on this floor, in terms of infrastructural development, you would discover that Africa is the only continent that has not been developed. And so, fund managers have money. They are keeping these monies in some places, maybe making 1% interest, keeping that money wherever it is in a year. They are looking for where to invest this money. So I tell you that they are going to come to Africa. They will come to Africa because Africa is the only continent that is not lit up. It's requiring infrastructural development. We've seen from the slide shared by Delano, from generation to transmission to distribution, all these require huge investments, and they are going to come into Africa. One thing that we must do, just like Prof said, such that we don't sit here in Africa. They come with their money because they're certainly going to come, and then decide to also come with their own experts. And I've seen that in this room there are many more younger lawyers than the older ones. This is an opportunity for you to begin to create a niche for yourselves within the value chain. Develop your capacities. And when I say you develop your capacities, I'm also doing that as well. Not minding the fact that I'm 30-somewhat years at the bar, I'm also developing my capacity and trying to get some part of the value chain to position myself, know what I ought to know in that particular place, so that when experts or when investors come and they say, well, this is this area that we need someone to offer service to us, they can readily come to me. They would have checked the things that I've done previously and discover that I have what it takes for them to hire my service, and they are going to get value for that particular service. So this is perhaps all that I'm going to say, perhaps by way of information. The Singapore Convention, by the way, that lends support to the enforcement of mediation settlements, has found its way in the arbitration bill that is being proposed right now. It has passed the lower house, the House of Representatives, has actually passed it. It has been sent to the Senate for concurrence, and we were very deliberate about making sure that the Singapore Convention was made a part of it. So perhaps before the end of this year, God willing, we would have that bill passed as law, and you can be rest assured that the same enforceability that comes with arbitration would also be enjoyed by mediation reports. So I thank you very much for the opportunity to speak to you this afternoon. Thank you. So it's not been easy speaking after these professors, and even our moderator actually had a presentation, and I'm sure you would like to put your hands together for our moderator as well. Thank you so much, sir.
Thank you. I told you in advance that we have the best panel here. And I'll tell you a little secret. When I was asked to be moderator, it was very easy to accept. So nobody knows what I can do or not do. I can say I'm the moderator. All right. Ladies and gentlemen, thank you very much for your patience. One important thing that the learned Silk, Michael, brought out, which is very important. I want to say this. Let us remember that the purpose of these presentations here is the use of ADR as a tool for easing investments. So not so much an advocacy that we should adopt ADR, but how can we use ADR as a tool? And one of the things that I think has been consolidated right from when Professor Elias spoke up till now is this, that ADR policies, if properly set out, will, and they can get the confidence of foreign investors and other investors, it will aid very quickly to encourage investments. Why? Because we know that though disputes are inevitable, people who know that they can be resolved quickly, inexpensively, effectively, without disrupting too much of relationships will find it attractive. I think the additional layer that Michael has added to it is, look, ladies and gentlemen, we need to look inwards. Are some of the things that people are complaining about, is it because of the system itself, or is it because of a deficiency we may be tolerating in ourselves and in our practice that is making it easier to amplify those negative aspects? And I think that is the major thing that I take away from what Mekio SAN has said, which I believe we need to really think inwards, that even if you have the best laws, even if you have the best regulations, even if you have the best environment, if we ourselves are not committed to two things, the principles and the ideals, at the end it will all still be in vain. Now, coming up next after this, and without wanting to waste any further time, I'd like to ask the IT person, please, is Dr. Adara Legbe, has he been queued? We'd like to welcome Dr. Bayo Adara Legbe is a partner of Babalaki & Co. I can easily say he's one of the leading authorities and thought leaders in the area of energy, especially oil and gas in Nigeria. And I will be bringing him on now to give us the final presentation on this panel. So, are we on cue, Dr. Adara Legbe, please, online. Thank you very much.
Thank you so much, Mr. Moderator, for that warm and kind introduction. I believe that we can all hear me as I speak. Good afternoon, ladies and gentlemen. Unfortunately, I'm unable to join physically. I apologize for this, but nevertheless, I will try my best to do a follow-up on the excellent and masterful presentations by the previous speakers. I think that the organizers should be commended for this topic, energy transition and ADR. But I just have a few thoughts that I wish to share with you this afternoon. And the first has to do with the topic. The topic suggests that it is actually settled which energy we are all transiting to. And I wish to suggest this afternoon that that is actually not quite so. Daniel Yegin sent an article out a few months ago. Daniel Yegin, for those who do not know, produced an excellent book called The Prize. And he dealt with a lot of geopolitics and oil and gas and so on and so forth. And essentially what he was pushing out in the article, was published in Financial Times, was that oil-rich developing countries actually are not agreeable to this idea of energy transition. Energy transition is being propagated by Western countries. And their position is that hydrocarbon is dirty oil. And because of that, we need to transit to something clean. And they have suggested that renewable energy is the way to go. And by renewable energy, we all know that essentially we are talking of water, solar, and wind, and so on and so forth, essentially inexhaustible oil. And so that is the position of the developed world. But the developing countries take the view that it is quite unfair. And so if you ask, for instance, the Minister of State Petroleum in Nigeria, his understanding of energy transition is quite different. They believe that gas is the way to go, because gas is proven to be environmentally benign. And so it's important for me to just flag this point, because even though the developed world is quite vehement in its position that energy transition translates to inexhaustible energy, which is water, wind, and oil, this is not settled, and the discussion actually is ongoing. And I think there is a point to be made in the position taken by the developing countries, because actually we did not know the potency or efficacy of hydrocarbon until the Western world came and introduced us to it. We have created infrastructure, we have suffered environmental devastation, and so on and so forth. So I think this has to be negotiated instead of taking a casual approach that a decision has been taken and the world is actually at one as to where it is transiting to. What is not debatable is that energy transition is on. But what is not clear is what kind of transition are we talking about? Is it gas or is it renewable? So it's important to make that point. The second point I want to make is that when we actually look at, and let us, even if we accept as a working definition that water, wind, and solar are the constituents of the transition, what is again clear in this is that, hello, can you hear me? What is clear about this is that it is very expensive. This discussion about energy transition to wind, water, and solar actually has been on for at least 30 years. When I was doing my postgraduate in petroleum law and policy, it was actually very topical. What is prohibitive about it is the fact that it's very, very capital intensive. Anybody will tell you that hydrocarbon exploration and production is extremely very expensive. And so when you now begin to talk about water, wind, and solar, and that its intensity in terms of the capital outlay, then we begin to have an idea. And so the point is that whether it is gas or renewable, is going to be very expensive. And because it's going to be very expensive, it's going to actually take the same pattern that we have had with hydrocarbon. And that is that foreign investors, as presenters have actually mentioned earlier on, foreign investors are actually going to be dominant in this because it's expensive. And what again that tells us is that what kind of dispute settlement mechanism are we going to have? The foreign investors actually are averse to the domestic system of dispute settlement. Under public international law, there is the principle of extraterritoriality. And that principle suggests that it is actually the territory within where, the territory where you are actually producing that you should litigate your concerns. But these foreign investors believe that invariably the respondents to their claims are sovereign states, because sovereign states own the resources. Whether you are talking of hydrocarbon or wind, water, oil, even though it is naturally provided for, it still has to be regulated within a territory. And because of that, it is the government, the sovereign states, that you will be suing in case there is a dispute. And so for this reason, foreign investors typically avoid the domestic cost of the host states where they are actually doing business. And so that is why they actually turned to international commercial arbitration. But between the late 60s and early 70s, they actually had bad experiences. And that was actually initiated by, when Gaddafi came to power, the late Gaddafi in 1967 or 68, when he came to power and he expropriated American oil producing companies, and they went to arbitration in accordance with arbitration clauses in the state contracts that they signed. And Gaddafi refused for Libya to show up at the arbitral tribunals, or where, and in some cases where actually awards were issued against Libya, it was a struggle. And so that was actually what led to the acceleration of the investor-state arbitration treaty as we understand it. And so we now have this transition of energy, and we are speculating what would be the model that is best suited for this. I'll just want to mention two things. The first is that the disputes that we are actually going to see in energy when there is full energy transition is not the same disputes that led to the development of investor-state arbitration. Actually, what caused the investor-state treaty arbitration was direct expropriation by certain states, mostly from the Middle East and also African states, developing countries. That does not exist anymore for the most part. So what we see is supple expropriation, what they refer to as indirect or creeping expropriation. And so because of that, we are not likely to see direct expropriation. And because we are not likely to see direct expropriation, we may not, even though there are foreign investors, we actually may not experience investor-state arbitration in this area. The other point I want to make is that, as somebody has said, when you talk about investor-state arbitration, it's actually a zero-sum game because it actually disrupts relationships. I'm not aware of a lot of cases where there is a foreign investor has taken on a sovereign state before investor-state arbitration and he has returned to business. Usually, they want a payout and they want out of the system. But it will be very different in respect of renewables, because as I mentioned earlier on, it's extremely very expensive. And these people, in foreign investors, are not going to come and set up infrastructure and then just get a payout and then leave. And so this is, I think, where ADR is very, very important. The virtues of ADR have been explained earlier on, but I would just like to highlight again that with ADR, you are actually not playing a zero-sum game. You are actually settling a dispute without expecting that you are going to end a relationship. And I think the morale for us all this afternoon, we have excellent lawyers and advocates in court. Increasingly, we have excellent arbitrators. The arbitration community in Nigeria is large. And I think we should not wait to be caught napping. Now is the time to begin to hone our skills in ADR, because ADR is going to play a very vital role. I would predict even more than investor-state arbitration, more than international commercial arbitration, and obviously, for me, much larger than what we are seeing in domestic litigation. So if ultimately the Western world wins, as it appears they are winning the campaign, because the clamor for renewable is very, very loud, and they are advocating for everybody to transit and basically dump hydrocarbon and transit to water, wind, solar, and the rest. And so when that happens, and we begin to experience disputes as we would, I would suggest that what we are going to see will be a lot of cooling down clauses, which essentially is equivalent to ADR. We will see a lot of mediation because of, as I said, on one part, developing countries are more mature and they don't pull the trigger the way they were pulling the trigger in the 60s and the 70s when they were actually seizing assets directly and they were liable for direct expropriation. They are better informed, they are wiser, and they are mature on one part. On the other part, foreign investors in energy in these sectors actually are going to be investing a whole lot of money. A lot money that when we compare what is already been invested in hydrocarbon, it really truly pales compared to what the expectations are for renewable. And so for that reason, I don't imagine that the foreign investors in renewable as against foreign investors in hydrocarbon would be playing a zero-sum game. They are more likely to expect to negotiate and resolve their disputes in a way that relationships, commercial relationships with sovereign states are not ruptured. And so my final word again is to thank the organizers and to make the point that now is the time, because the rest of the world are catching on to this. And so I think the opportunity that the organizers have used in framing today's topic affords us the opportunity, if I should say so, to actually remind ourselves about the need to hone our skills in ADR. Thank you very much for the opportunity.
Thank you, Bayo. We've really enjoyed that. And this has been such a loaded panel that we've overshot our time. But trust me, I have no regrets. The only regret is that, unfortunately, or regrettably, let me say, we will not be able to take any questions at this time because we're running out of time. And I also want to apologize to the panelists that I would not be able to ask you to please say a final word. I think all the things that you've said right from when Prof started, and I like the way all the issues raised have been addressed. The final word is just this. Please remember that we're looking at not just advocacy for ADR, but advocacy for ADR because ADR properly placed will be a very effective tool for easing our transition in a way that also benefits us as practitioners. I don't want us to forget that. And lastly, that although we think of ADR most times and we tend to think arbitration, but I think no doubt we're all going away from here this afternoon, including Professor Elias. He doesn't seem persuaded that mediation does have a very important and very effective role to play as well. You want to do a quick report
let
to
me
that?
cheat a little, yes.
Yes.
I have no doubt about the popularity and effectiveness of mediation. I've been very, very surprised by how things have been going at the Lagos multi-door courthouse, for example. When it started, I thought it was a very bad joke. But over the months and years, my younger colleagues have been telling me cases actually get settled. There was even one bank then for whom we had more than 100 cases. Like 80% of them have disappeared. So I do not doubt that. Maybe the point I was making was too technical. And it is simply that even at the end of arbitration, mediation, the mediator cannot put your signature on that settlement agreement. You have to put it. And if you say you are not signing, then you are not signing. There's no resolution. That's the only point I was making when I was saying it is not compulsory in the way that arbitration is.
Okay. With the greatest respect,
it's not about the
can I say something about that? From if you are, there are two things, and I think either Godwin mentioned it as well. When you do sign an agreement to mediate, it is a contract, and it is enforceable as any other contract, and you can actually do specific performance. Test me out. I won't say more than that here, because if I say more than that, I'll have to issue an invoice.
That's post-dispute arbitration. That's not mediation.
Secondly, once in some of the cases that Godwin also mentioned, and I'd like to say that, by the way, I chose not to say too much because I thought the ground had been adequately covered. But one thing, there's some provisions even in the civil procedure rules that we don't seem to be aware of. There's a provision for recalcitrancy in mediation that allows the ADR court, ADR judge, where a plaintiff has been recalcitrant vis-a-vis the mediation process, can strike out his claim, and where is the defendant, the ADR judge can actually enter default judgment. So it's not as toothless as it is. Many times within LMDC, we have quarreled with them that they are not using all the powers available to them. But they say that they're not doing so because they still want to encourage people into mediation. But trust me, mediation is not as harmless as you think it is. Gentlemen and ladies, please let me not break my word. I don't want us to get into a prolongation. We've taken long enough. And I think all I will say now is, on behalf of the organizers, I want to say a very big thank you to Professor Elias. Sorry? Huh? No, not me. Okay. Professor Elias, Mrs. Delano, Godwin, Omaka, Professor Fabonlu, and I want to say Pastor Mekio. SAN. I want to say thank you to what I believe I've had the privilege of being a part of. And now you'll understand with me when I said at the beginning that I had a sense of privilege. It is really a privilege to be a moderator of a panel of this standard. So thank you for allowing me to moderate you, and thank you for receiving them. A round of applause for them. I'm going to be calling with the deepest respect on Mrs. Flora Lakija to please help us with the presentation of plaques to the... I know, I didn't warn you before, please forgive me. I'll need you centrally located like that. Okay. We start with Professor Bola Elias, Senior Advocate of Nigeria. Babatunde Fagbonlu, Senior Advocate of Nigeria. YC Mekiao, Senior Advocate of Nigeria. Godwin Omwaka, Senior Advocate of Nigeria. Mrs. Jumoke Delano. And oh, forgive me. You're not done yet. You're not done yet. Yeah, okay, yes. There is a plaque to G. Elias and Co. as one of our sponsors of this event. And Prof himself is here.
Okay, I was wondering whether to get somebody else to come and take that one. Thank you.
The representative of Axela Limited. Axela, are we here? Axela Limited. Eco Disco. Eco Electricity Distribution Company. No, you haven't done yet. You have to present to me. Even okay, that's true. I'll just. Well, to Dr. Bayo Adanadegbe, we'll ask you to please imagine that you have received it. You are deemed to have received it. So, yes, I'm going to request that we just take a group photograph, please.
fine. Melanin for the wheel. Your smile is messing with my mind. Just call my phone, make it ring go. Let me just look at your face, oh baby. I'll never forget this now. May you just come to my place, oh baby. I might never let you out. Your sister driving me so crazy. Almost he gets me, oh. Almost he gets me, oh. Oh, hey. Baby, you're a 10 over 10. Now it's in on the tell all my friends. I brag about you, I don't send, oh, I don't send. Oh, I wanna tell you what's on my mind. I'm giving you love, yeah. I'm giving you love, yeah. You're the one, whatever you want, yeah. Oh, baby, just call me on the phone. I'm feeling your body. Got it all for me, don't you know? Oh, and I feel your body, don't you know? Oh.
Good afternoon, everybody. Welcome back from tea break. We're sorry it took too long, but we had to take the previous session before we had our tea break because most of our speakers were on ground and some had other appointments. So we quickly took that session, after which we had to go for our tea break. So we are welcome back. We are welcoming you back to the session. Now we're moving on to the last and final session of this conference. And moderating that session is Mrs. Folake Akim-Oladun. She'll be introducing the other speakers on how they will be speaking. Welcome, ma.
Okay, there we go. Good afternoon, everyone. I think we just give everyone a few minutes to just come in. We should start the session in a few seconds. Okay, I believe we can go ahead and start. Like earlier introduced, my name is Foluke Akim-Oladun. I'm the managing solicitor of Trison Law Chambers, a maritime lawyer and an accountant, and I have the privilege today of moderating this session on AFTA, capitalizing on the trade agreement to improve African energy transition. One of the reasons why I believe I was called by the organizers to moderate this is because of the work that the National Action Committee on the implementation of AFTA in Nigeria has actively been working in this space, and I have the privilege of heading the transportation work stream. And I also have with us today my boss, in quote, Mr. Francis Anato-Ogu, who is ably represented by Mr. Michael Faniron. I just want to confirm if he is still on. Can we kindly confirm if he's still? Yes, great. Thank you, Mr. Faniron. Mr. Faniron will be representing Mr. Francis Anato-Ogu. Just by way of a quick introduction on Mr. Francis. Mr. Francis Anatogu is a senior special assistant to the President of the Federal Republic of Nigeria on public sector matters and the secretary of the Nigerian National Action Committee on the African Continental Free Trade Area. In that role, he heads the secretariat and coordinates the Nigerian implementation of the AFTA. He was the secretary of the Presidential Committee that conducted the impact and readiness assessment and stakeholder engagement that resulted in Nigeria joining the Continental Free Trade Area. He studied mechanical engineering at the University of Nigeria and has an MBA from the George's Business School, University of Cambridge. Now, Mr. Francis is going to be talking about, his representative, Mr. Michael, on behalf of Mr. Francis, is going to be sharing with us today some of the things that the National Action Committee has done with respect to the energy sector. So if Mr. Michael is on, kindly put him on to speak on AFTA and the oil and gas renewable energy space in Nigeria. Mr. Francis, can you hear us, sir? Mr. Michael, can you hear us, sir? I'm sorry.
Good afternoon. I'm happy to be here. My name is Michael Plania. I lead the strategy planning and coordination for NAC Secretariat of AFTA in Nigeria. Can you hear me?
Yes, we can hear you, sir. Sir, kindly make your presentation. You have 15 minutes.
Yes, I don't need more than 10 minutes actually because, okay. Am I able to share my screen? Can you allow me to share my screen?
I believe you can, sir. Kindly try.
I can't. You say host disabled
You
participant.
can. Oh.
I can't. You need to enable me. Okay, I think I can now. Yes, thank you. Let me know if you can all see my screen.
Yes, we can, sir.
All right, sir. Thank you. Once again, I apologize on behalf of Francis, who is not available, who has to travel earlier today. And I'll be sitting with him on this. So I'll be talking, like you've mentioned, on some of the things we've done in the oil and gas space for AFTA. Like you all rightly know, that the objective of AFTA is actually, one of it is to create a single market for goods and services in Africa. About 55 countries have signed on to AFTA, which make it the biggest continental free trade area in the whole world, with a combined GDP value of $3.4 trillion and about 1.3 billion people, which has made it possible for businesses all over Africa and different countries to increase their market segment, to increase their customer segment, and which will make it possible again to enhance competitiveness and promote industrial growth. And one of the things that this is doing is actually to eliminate tariff on about 90% of tradable goods and offer us access to other markets that probably we wouldn't have access to as a country, as individual, and as other as entrepreneurs. So that these are some of the things. So because I need to run quickly. So that's what AFTA is all about. I'm sure we have that. So currently, the phase one is already concluding. So in AFTA, we have trading goods. That's things that have to do with goods, trading services. Those are some of the areas that we're looking at. There's protocol on free movement of persons as well, and dispute settlement mechanism. And what we are doing now with NOTA is around investment policy, around competition, intellectual property rights, the economy, and a lot of negotiations are ongoing between the countries on the tariff of the different modes of supply for goods and services. So those are some of the things that are going on now. In AFTA Secretariat here, we have entered the implementation session, implementation era. For the last 1 or 2 years, what we've been doing, I've been planning. Though we are still on planning, we are still last year we developed a national implementation strategy, which we released a select release. We have not released it totally to the public, still undergoing approval processes. However, we are still updating that, but we don't want to wait until that is fully ready before we start implementation. So we'll be implementing as we go along, and we'll be updating this implementation strategy. Hopefully, sometimes around June, we should have a document that will be ready for public circulation in terms of what we've done. And based on what we've done and compare with other countries, I think we've really done a lot of work around the implementation strategy. And we collaborating with other countries, and other countries have been learning from us. In terms of energy, we know that Africa is a continent with rich natural resources. Africa actually accounts for 8% of the global oil output as of 2020. So there's huge potential for Africa, for Nigeria, for example, regarding natural gas. We have huge deposits of natural gas in Africa. More than 75% of Africa exports is actually oil and gas. And however, this has not been judiciously used based on the issue that we have as a continent. So we believe that if this is well used, this can accelerate growth of the continent and in general, and in Nigeria as well. So in summary, oil and gas is a very important natural resource for Africa that we use, especially the fossil fuel. So the discussion of transition, I will talk around transition maybe at the last slide of this presentation. So in terms of oil and gas, we believe there are a lot of opportunities for oil and gas within after implementation. We have the Africa trading, which will become easier again, more than it has in the past. For example, when we talk about trade barriers, which is which we have now, and after it's all about elimination of trade barriers. So currently, African country has been very vulnerable to international market. You see, for example, now what is going on in the global oil market is affecting everybody. So we believe that if you have a market, an African focused market, it will reduce the vulnerability that we have when it comes to global issues. And we believe that this will oil and gas producing country will benefit more from global markets and the domestic market as well. And another thing is the value addition to oil and gas resources, which we believe is going to boost employment, is going to help us in generating a GDP. One of the key theme of the PIA that was signed in Nigeria last year was value addition, which the country, Nigeria, for example, aims to pursue. And for me, that's one single thing that I think is the best thing to in that PIA, is that around value addition for the country as a whole to actually add value to oil and gas resources. Because we export these natural resources, we export them in a good way, and again, we import. If you look at African countries, if you look at the top 5 items that we import in Africa, petroleum products actually top the list of the imported products in Africa. So we believe that when we begin to do this, then we can do this within Africa, and we don't have to depend on importing them from Europe and importing them from America. And we believe that this increase in trade, again, will trigger significant increase in energy consumption, because when there's industrialization, we believe that there's going to be increase in energy consumption, and most of it we can buy from each other, and we can make more money from each other. We can more than the OPEC output. We can do a lot of trading within Africa, and we believe this one will trigger substantial investment again from overseas country, because we have a market, a big market that's actually provided with lower risk which I think is going to be a very good value proposition for investor. And again, because now there's going to be reduction in cross-border barriers. So the oil and gas company can now begin to integrate from one country to the other because we have similar tariff. We're going to have similar commercial terms across Africa. So it's easy for one oil company to do business in different African countries without minding that, okay, there are going to be different policy or different law that is going to be a country. So, and again, which again comes about by the protocol for reasonable resolution of investor state disputes, because the protocols are going to be a bit more similar. So dispute resolution between investor and the state is going to be easier, because what you have the protocol in Nigeria is going to be similar to the protocol you have in Mozambique and what you have in Ghana. So we believe this is going to make it easy for investor to make investment in oil and gas sector in Africa. Then considering the Nigerian huge potential, now you are looking at Nigeria. We believe that Africa, after actually presenting a triple-fold opportunity, if Nigeria can establish itself, and there are different ways that we think we can actually have a lot of opportunities in Nigeria, taking advantage of AFTA. First, that we have the population. So and again, I know a lot of people are concerned before AFTA was signed that Nigeria become a dumping ground. That's why we are doing quite a lot of things now to ensure that Nigeria is actually an exporting country. What we want to do, the aim of AFTA for Nigeria is actually to capture 10% of imports to Africa. So if you capture 10% of the import that come to Africa annually, and that becomes an export from Nigeria, we would have captured a significant amount, about $6 billion. I guess I'll look at it again. That would have captured in terms of that export. So one of these is that if Nigeria can become a refining hub, for example, for Africa, you can imagine how much we'll be making. Like I mentioned, most of African countries, the topmost thing that they import is a petroleum product. So if Nigeria can be a refining hub, you can see those products that we're going to be getting. And again, with our huge gas resources, we believe we can become a major exporter of gas to Africa. For example, we have a lot of gas projects that are going on now. About last 2 or 3 weeks, Nigeria just signed an MOU with Equatorial Guinea to have a pipeline. We have the Trans-Saharan one. We have the one going to Morocco. We have quite a lot of things that are actually in the plan that we can make us to be actually a very good exporter of gas to African countries. Then another thing is that we can become a key exporter of oil and gas skill and capabilities, because Nigeria is a bit more advanced than most of these countries in terms of the oil and gas sector. We have a lot of skills with our local content policy that we've developed. And if you look at the NCDM human capital analysis, so we believe that we have a lot of things to export to Africa in terms of skill and capabilities. Then in terms of even oil and gas fabricated components and models, I was talking to NCDMB recently, and Senegal were here in Nigeria to actually come and learn from the NCDMB. They want to start their own local content policy. And one of the things that Nigeria should be aiming for is actually to make sure that, okay, we train these people and begin to capture that market so that we can, at least while they are developing theirs, we can actually be the ones supplying those skills and capabilities. There are a lot of opportunities in oil and gas in terms of goods, in terms of services. Look at my screen. We see a lot of goods, services in oil and gas that you look at. There's huge gap. What Africa imports, and if Nigeria can capture 10% of that, you can see the huge amount of dollars that we will be getting from there. Again, in terms of skill as well, what Africa imports, and if Nigeria can, what Nigeria imports and what we export. For example, you look at this in terms of skill, we import $11.3 billion and we only export $0.06. So you can see, so if you can double this, you can increase this one. If African is not importing them from outside Africa, then we can capture 10% of what Africa imports, 34.63 billion. Imagine we capture that one, that's $3.6 billion already in terms of oil and gas trade-related business services that we can give to Africa. So these are some of the opportunities. And again, what is going to bring about these opportunities around the rules of origin within AFTA something that's called rule of origin, which means whatever that would be acceptable as that can enjoy that after benefits must have some percentage of it that's manufactured or processed in one way in Africa. So we believe that. And again, the other one is industrialization. We believe this is going to lead to industrialization in Africa. Like I mentioned earlier, there's going to be increased consumption of energy. We believe that there's going to be increased demand for skills, increased demand for fabricated goods. So industrialization is another area that is actually going to bring rise. So these are the two key areas that we think will bring all these opportunities that we've been talking around. So in terms of our implementation, what we've done is that we have...
Sorry, sir, you have about 2 minutes left.
Okay, no problem. We have implementation strategy, and we have about 7 goals and some bold actions, which we are implementing now. And so these are sample oil and gas intervention and initiative that we are working with the Ministry of Petroleum Resources and all their agencies, growing gas to African market, expand domestic gas utilization, increase integrated plans. So you can see some of these. These are just sample of the intervention initiative that we have. And one of the major projects that we are doing now is to do a baseline assessment capability of oil and gas in Africa. So when we do what are the baseline assessment in terms of what their needs will be in the next 10 years, and what are the gaps in terms of skill, in terms of services that are there, then we want to do this. Once we know this, then Nigeria will have the opportunity of knowing where to lock in some of those opportunities. And this is the way this is our own implementation conceptual framework. We are growing value chain across trading goods and trading services, and again across something that we are already being exported currently, and we have some enablers, trade facilitation, trade policy, factor market integration, institutional coordination, and some of the things that we do. And like I told you, we're in phase 3. We're in the implementation mode now. So that's what we plan to continue to do while we are updating the plan that we have currently. And we already have technical working groups across different sectors. So the blue is the trading goods. We can see oil and gas there. We have trading services, and we have enablers. So we've set up TWGs across different sectors. Some have not set up, but we are working with them to set up TWGs. We have project managers that are managing the different interventions and initiatives. So those are some of the things that we are working on, and that is where we are. And we'll be reaching out. One of the key things I want to do this year is to partner with trade associations, to partner with a lot of associations, and sensitize them on what AFTA is, and let them know more about AFTA, and collaborate with them, especially people like your own organization as well, who partner with this a credible partner for people to know what AFTA is all about and how they can take advantage of after implementation. I think I'll stop here. If there are questions that I can take. Thank you.
Thank you very much, Mr. Faniro. I hope you still have. I hope you still have a few minutes. I know that you will have a flight to catch in about an hour's time. Have a few minutes.
But I can take the next 3-4 minutes. So.
Oh, okay. So that would probably mean I don't know if we have anyone in the audience that would like to ask a question. Okay. I'll just take the question, probably one major question. The question is, will AFTA help Nigeria to improve the development of renewables, or should Nigeria just focus on fossil fuels? That's the oil and gas sector alone. Or does AFTA create an environment, essentially, for Nigeria to be able to develop its renewables?
Yes. We are looking at the whole of energy value chain, and so there are opportunities as well, interventions around the renewables that we are pursuing, but again, not as vigorously as we are pursuing the one of the fossil fuel now. For now, personally, I believe that we need to use our resources of what we have now to develop, to industrialize. I have my own personal view on energy transition. I believe in energy transition, but I don't believe that it should be foisted on us when we are not ready. I think Nigeria should be ready, Africa should be ready for energy transition, and not something that is going to be foisted on them for them to just adopt. I think it's a selfish agenda of developed countries. But again, taking my personal view aside, there are opportunities across all the sectors of value chain, including renewables, through AFTA.
Okay, thank you very much, sir. We had to quickly take on Mr. Faniron because he had a flight. So thank you once again. Can we give him a round of applause? So I'll go ahead now to introduce the rest of the panel. Once again, apologies because of Mr. Faniron's schedule. We had to quickly have him speak. I would introduce our speakers not in any particular order. And for those of our speakers that are here physically, please do join me on stage once I call your name. We have here Mr. Dolakbo Akinrele, Senior Advocate of Nigeria. I believe he's connecting with us virtually. Yes. Okay. Mr. Ade Dolakbo Akinrele, Senior Advocate of Nigeria, was educated at Clifton College, Bristol, University College London, and University of East Anglia, Norfolk. He's a life member, Bentham Law Society, University College London, a member of the editorial board, the Nigerian Maritime Law Journal, a senior advocate of Nigeria, and a patron of the Oil and Gas Law Society of the University of Lagos. He's a board member of the Oxford Journal of World Energy Law and Business, University of Oxford. He has written numerous articles, including Transparency in the Nigerian Oil and Gas Industry, Journal of World Energy Law and Business, Volume 7, June 30th of 2014, and The Current Impact on Global Crude Oil Prices on Nigeria, an overview of the Nigerian petroleum and energy sector, and the Journal of World Energy Law and Business, Volume 9, Issue 5, October 2016. Ladies and gentlemen, please let us welcome Mr. Ade Dolakbo Akinrele, Senior Advocate of Nigeria.
Thank you. Thank you. Thank you.
You're welcome, sir. Our next speaker is Urogana Ogbuefun, the Managing Director and CEO of Stars Investment Company Limited. She is ably represented by Sophie Uzo, who is the Head of Research and Development and Projects of Star Investment Company Limited. While I read Ogbuefun's profile, can her representative, who I understand is here physically, kindly join me on the stage? Oroma Ogbuefun is the Managing Director and Chief Executive Officer of Stars Investment Company Limited, where she manages the affairs and operations of a fleet of 12 ships working deep offshore Nigerian waters, supporting the oil exploration and production activities of international oil companies. Urogama holds a bachelor's degree in biology and psychology and an MSc in public health. She's an alumni of the Harvard Business School, a member of the Institute of Directors, and a founding member of Women in Energy Network. She's also the chairman, Finance Membership Committee of the Ship Owners Association of Nigeria, and a director of Eagle Watch Security Limited. In 2013, she emerged winner of the maiden edition of the Next Titan Entrepreneurial Reality TV show and has received several awards for her business acumen, including 2 Eagle Awards for Young Entrepreneur of the Year, the Futures Award nomination for Beauty category in 2016, and the recipient of the Entrepreneur Africa Awards 2021 Outstanding Female Entrepreneur of the Year 2021. She's a mother to beautiful twin girls and is committed to the growth of female entrepreneurs, a passion she drives through mentorship and support. Ladies and gentlemen, let us make welcome the representative of Mrs. Ogbuefun, Ms. Orugama, sorry, Sophie Uzo. And our next speaker, I want to confirm if she's here physically or is she joining us virtually? Our next speaker, Mrs. Patricia Igwebuike. I hope I got that right. Please, ma, forgive me if I didn't pronounce that properly. Igwebuike. Okay. Is she here physically? No, okay. Can we confirm that she's connected with us online if she's not here physically? While we're trying to do that, Madam Patricia is the immediate past Special Advisor on Legal Matters and Petroleum Resources to the Anambra State Executive Governor. She was the first female lawyer from the Nigerian Bar Association to be appointed to the National Judicial Council, the Nigerian counterpart of the UK Privy Council and Supreme Court, the country's highest judicial policy-making body from 2014 to 2016. Madam Patricia has a lengthy record of volunteerism and leadership. She represents the state in the National Gas Expansion Program, NGEP, at the Federal Ministry of Petroleum. She serves on several committees in the state, most notably as Secretary of the Anambra State Law Revision Committee. From 2009 to 2010, she was a member of the State Local Government Joint Account Committee, representing Anambra North Senatorial Zone. She is the Secretary of the General Purpose Committee of the Nigerian Bar Association, a committee entrusted with screening future senior advocates of Nigeria. In 1987, she was admitted to the Nigerian Bar, and in 1998, she was admitted to the New York State Bar, the United States of America. Ladies and gentlemen, please join me in welcoming Mrs. Patricia. Can you hear us, Ma? Let me just be sure that your connection is working. Okay, she said, okay, noted, noted. Okay, so at this point, I would like to kindly call upon Mr. Dolapo Akirele, Senior Advocate of Nigeria. Yes, sir. Can Africa take advantage of its existing AFTA to stimulate such trading of renewable energy within the continent? Please use this as the basis for your presentation, and you have 15 minutes, sir.
Well, thank you. I hope that I can do justice to that question within the 15-minute time slot. The core of my discussion today is on the challenges that will confront the adoption of the renewable energy route by Africa, particularly in the face of the AFTA, and whether the AFTA will enhance African energy transition. The AFTA is still finding its feet in terms of negotiations on non-renewable energy, such as the impact of projects across borders, factors that can impede growth, and synergies and pipeline management, etc. So there's still a lot to be done with AFTA. An undoubted beneficiary of AFTA is the energy sector. And of course, both oil and gas operators in stream and also in the midstream and downstream sectors of benefits. Oil and gas and mineral resources remain the biggest play in Africa. And these account for 75% of the continent's exports. And with the high growth potential in oil and gas, it will still have a role to play in the short and medium term going forward. Estimations vary, but recent figures put Africa's proven gas at about 487.7 trillion cubic feet, with proven oil reserves in the region of 125 billion barrels. So clearly, oil and gas is still the main feature of energy in Africa. However, trade barriers are there, and they do bring about high import tariffs, and many African countries are vulnerable to the international market resells in terms of petroleum products. The AFTA will potentially end this practice, as oil and gas producing countries will benefit from global markets as well as the domestic markets, focusing more on growing intracontinental oil and gas trade, and will give countries the autonomy to govern their international trade agreements, which have often left African countries on the losing end. How will AFTA deliver on the energy transition from non-renewables to renewable energy, particularly in the much needed area of electrical power generation? Despite severe challenges we've all seen with generation and transmission, Nigeria has already set up a regional template in renewable power generation through the Kainji Dam and the Shiroro Power Dam as well. These are hydroelectric power projects, and Nigeria sells some of these power through the West African Power Pool of 2006. This is a specialized agency of ECOWAS and it covers 14 to 15 countries of the regional economic community. In 2007, Nigeria increased its supply of electricity to Ghana through the West African Power Pool. The West African Power Pool agreement between Ghana and Nigeria and Ivory Coast also shares electricity between the countries. So we do have a certain template on this basis. Now, in his policy brief, Accelerating Green Energy Transition in Africa through Regional Integration, 2020, the South African Institute of International Affairs stated that individually, most African countries lack the financial, technical, and human capacity needed to fully implement clean energy transition. External partners are required to enable Africa to address its energy deficit.
Sorry, sir, are you still with us?
Hello?
Oh, okay, sir, we lost you for a few minutes. We lost your connection for a few minutes there, for a few seconds there. But we can hear you now. You can.
But, okay. All right. So I can't seem to. Can you hear me?
Yes, sir, we can hear you.
Okay. So external partners, as I said, are required. We have which I think is a critical aspect in building regional markets for goods and services. Obviously, free movement is an essential part. And by consolidating poor and fragmented African countries into a strong market, then there'll be a major change in the dynamics of AfTA. The second important trend is the evolving European and African relationship. And as previously stated, a regional approach to addressing the African energy deficit is not new. As, sorry, I'm just having trouble accessing my paper. Could you,
your paper is being shared right now, sir. I don't know if you can see the screen from your side.
Yes, I'm having a little bit of trouble. Okay, that's fine. So as I said, the AfTA intends to scale investment in regional infrastructure projects, given that renewable is a significant component of the regional power pools. This can accelerate the transition to green energy. The second phase of negotiations is centered on protocols for cooperation on investment, intellectual property rights, and competition policy. This protocol provides for national and continental investment, as well as support for existing investment. A study in 2021 by the Economic Commission for Africa, entitled Energy Prices in Africa, Transition to may not meet its Sustainable Development Goal 7, SDG 7 targets. The study indicates that millions of people in Africa do not have access to electricity, and millions have no access to clean cooking fuel. Meanwhile, electricity access in 24 African countries are below 50%. The report cites Liberia, Malawi, the Central African Republic, Burundi, and South Sudan, as having stagnated or reversed in electricity access. Countries like Nigeria, DRC, and Ethiopia reportedly have the biggest electricity access deficits. Access to clean energy is an essential component of this transition. Deployment and implementation, supplying economies with affordable fuel is integral to supporting actions for faster development of the sustainable development. The ACA, Africa and biomass instead of diversifying resource non-renewable. I'm going to move down to the recommendation. The report recommends that countries must provide an enabling environment for crowding in, apply cost-effective tariffs, paying attention to efficient generation of electricity to lower the cost and provide incentives and mechanisms to increase the share of renewable energy in the power system. The study or diesel and facilitate full deployment of renewable energy prices, lowering of the cost of production and tariff setting technology. Now I want to switch to AFTA, and of course a lot has been said about it, and I won't overpress the issue. It's been described as a game changer. The operational phase has kicked off. It was meant to start in 2020, but it started in 2021. The most obvious challenge with AFTA is a lack of a manual or information for African businesses about the AFTA and regarding the ways it can take advantage of it. And a substantial percentage of African citizens and businesses are still unaware of its terms, particularly the tariff arrangements. There is a knowledge gap on AFTA. This is also the challenge. There is also a challenge with regional economic communities, monetary unions, free trade areas. There exist several, and I will just run through a few of them. ECOWAS, of course, we all know, established in 1975. ECAS, that's the West African Economic Monetary Union, which was established under the French colonies, the ex-French colonies, Benin, Burkina Faso, Cote d'Ivoire, Guinea-Bissau, etc. They're all within the ECOWAS. CIMAC, which is the Central African Economic and Monetary Community, another French creation, and the Tripartite Union, which is the free trade area Southern African Development Community, and EAC, the Eastern African Community. And of course, there's SACU, which is also a Southern African Customs Union. Regional and pre-existed the AFTA. And the challenge with AFTA is how does it build on these blocks? How does it use these reunion, the frictionless, the borderless system that it wishes to put in place? Article 19.2 of the AFTA agreement provides that state parties, regional trading arrangements, and customs unions, which are attained amongst themselves, higher levels of regional integration than under the agreement shall maintain such higher levels among them. Organization and regional integration in Africa, and therefore the implementation of AFTA's commitments will take place on different tracks. This is a unique formula. It means that the regional economic so, of course, other regional economic union, the Sahel, Saharan states, and the Intergovernmental Authority on Development. Now, given that the majority of intra-African trade is conducted within RECs, institutions like this will play a central role in the African trade landscape. They will also contribute to the finalization, implementation, and application of ACTA. Now, what is the institutional architecture of ACTA? And I will go through this very quickly, bearing in mind the time. The main layers are two. The first, which is the top layer, and that's the apex body, is the Assembly Committee of Senior Trade Officials, and the AFTA Secretariat, which I believe is currently located in Ghana. The second layer, which are going to be the ad hoc institutions, would be the committees on trade in goods, trade in services, rules of origin, trade of facilitation and customs, cooperation, non-tariff barriers, technical barriers in trade, sanitary and phytosanitary measures, and trade remedies. So the nuts and bolts of AFTA, really, after we are now essentially in what we call the phase one of implementation. Phase one of implementation, from my understanding, and of course those who are doing it every day can update me. We have not quite finished phase one. There's still issues of rules of origin, and there's still a lot of issues that need to be ironed out on tariffs, etc., and tariff concessions, etc. It is being negotiated in 3 phases. This is the AFTA. And there is the understanding that after phase one, we will move to phase 2, which is an essential phase and addresses investment, competition policy, and intellectual property rights. Phase 2 was meant to have been finalized in 2021, but it hasn't. And clearly phase 2 is critical, especially for foreign direct investment. The decisions made during these negotiations for phase 2 and confidence in African markets. Protections for intellectual property IP rights and an enforcement mechanism for IP violations would enhance collaboration and allow investors to confident IP and best practices with African countries. The type of knowledge sharing is critical to the development of industries like to align with the international standards and becoming more competitive on the global stage. Phase 2 is expected to facilitate the continent's ability to integrate further into global supply chains, and especially as companies look to diversify their supply chains. I'm going to jump to the post-completion negotiations. Obligations will be the responsibility of individual states. The AFTA does not have a supranational institution. Subsequent technical support and surveillance measures will be necessary to prevent uneven or incomplete outcomes. Experiences in the regional economic community, free trade areas.
You have 2 minutes, sir. You have 2 minutes, sir.
Okay, all right. I'm going to jump straight to my conclusions then, which are, of course, we understand that the global energy is in transition. The Paris Climate Accord in 2015 really set a marker down on the impact of climate change. The COP26 of 2021 in Glasgow followed on from the Paris Accords, where the objective is 5 Celsius. So there's a climate driver that is pushing things, and inevitably, Africa still has considerable renewable resources, hydro and wind. and there will be opportunities in solar, of course. There will be opportunities for Africa to shift focus. In conclusion, will the AFTA strengthen the continent's energy transition? Well, it'll depend on a number of things. The ability of economic communities. 2, the ability to attract FDI investment into the solar, wind energy sectors. 3, the ability to put in place a robust phase 2 of the AFTA, and 4, the ability to create there must be a guarantee of security of investment, both economically and in terms of the security of the general landscape, which has been challenged in recent, over the past 10 years in Africa, particularly in Nigeria. Transparent adjudication of disputes is without delays, is truly frictionless infrastructure on land and sea will be necessary to deliver all the renewable energy investments that we need. I will end with the challenges to AFTA. The countries at the moment still favor protectionist policies in their African trade outlook. There is still unwillingness by state parties to ratify all the articles of the agreement, exemplified by prolonged negotiations on phase 1. As I said before, there's a lack of a manual on the information of the African business for African businesses and citizenry, and there is a lack of a customs infrastructure and policy to be able to complement the AFTA's customs and tariff obligations. Only 3 countries in the AFTA so far have infrastructure and systemic customs capabilities on par with AFTA's benchmarks. And so it is important that these 3 challenges are met in order for us to meet the obligations and the challenges ahead. Thank you for listening.
Thank you very much, Leonard Sil. Please, a round of applause for Mr. Dolapo Akinrele, Senior Advocate of Nigeria. I want to ask the audience, thank you very much, sir, for that very insightful presentation. I have quite a number of questions, but I'll first open the floor to attendees to kindly indicate if they have any questions. Do we have any questions? Okay, so I'll go ahead and ask mine. Leonard Silk, are you still with us?
Yeah, I am.
Okay, sir. So you spoke essentially on the different aspects with respect to how this transition dream can happen. But the first question to even ask is, should Nigeria be looking in that direction in terms of transition in the first place? And let me just give a context to my question. So our previous speaker says, in his personal opinion, Nigeria shouldn't even be considering renewables when we've not exhausted the potentials that the current fossil fuel market creates. However, there's on the other side of the coin the fact that the world is going to develop renewables, and African countries are already being considered as interconnectors for renewable energy, such as land, for wind power, and for solar. So, sir, in your opinion, what do you think should be the focus as far as energy is concerned, particularly with respect to electricity and Nigeria's availability, probably excess availability of oil and gas in comparison to other biofuel sources?
Okay, thank you. Well, I'm going to start with a quote, and that was from Sheikh Ahmed Zaki Yamani, who was the former oil and gas mineral resources minister of Saudi Arabia. And he said in 1983, the Stone Age did not end for lack of stone, and the oil age will end long before the world runs out of oil. And I think what I'm really saying is that there is a global
Leonard Silk, we seem to have lost your connection. Can you kindly repeat what the last thing you said, sir? Leonard Silk, can you hear me?
Yes.
Okay. Kindly repeat what you said in the last 1 minute. We didn't hear you.
Saudi oil 3, shake your money. Whose world runs out of oil? What he meant by that was that we have the oil still flowing, but there is a global push, climate change, renewable energy, etc. That is essentially an inevitable dynamic. So yes, I agree that Africa should monetize its oil and gas resources and do so better than it has done before. But we have to accept that the renewables is an inevitability, and it may run invariably side by side. Power is driven in Nigeria by diesel, and that is extremely expensive. Yes, we're transiting through gas, which is very viable, and but inevitably solar, wind energy will become viable methods, particularly when we look at the investment possibilities. So it is well on what it has at the moment.
Leonard Silk, are you with us?
Did you hear me?
No, sir. We did not hear what you said in the last few seconds.
Okay, my summary is that Nigeria, my summary is that Nigeria, as with other African countries, should monetize its oil and gas. And that is still the major play, and that's still the major mode of investment. However, the renewables category, solar, wind, and hydro, should be running side by side because the global dynamics are such that the world is moving towards renewable energy. So Nigeria and Africa should not be left behind. And therefore, there is a need to look at both in parallel.
Noted, sir. You also noted the Trans-Sahara pipeline and the MOU that Nigeria had signed with Equatorial Guinea. So in other words, we see that the trend seems to be moving towards monetizing our fossil fuels as against actually investing in renewable energy. But your position is we can actually do the two at the same time. How feasible do you think that would be, considering the fact that these are long-term investments, these are expensive infrastructure development programs?
Yeah, I think your point is well made. I mean, we should be focusing on our advantage, which is the oil and gas, and Africa continues to be a major producer of mineral oil and oil and gas. But I think that the issue is, let us start somewhere with the renewables. Morocco has started. I believe there are other African countries looking at renewables on a grand scale. Eventually, over time, maybe not in the next 10 years, maybe not even in the next 15 or 20 years, we will still be relying heavily on oil. But gradually, there will be a movement away, and we don't want to be left behind. So I think as we're monetizing the oil, as we're focusing on oil and gas, let us also focus on renewables as well.
Duly noted, sir. Thank you very much. Let us give the Leonard Silk a round of applause. Thank you, sir. Thank you, sir. We'll move on to our next speaker now. That is Urogana Ogwefun. ably represented by Sophie Uzo, the Head of Research and Development and Projects of Stars Investment Company Limited. The floor is yours.
All right, good evening, everyone. I'm going to be looking at this topic, capitalizing on the trade agreement to improve African energy transition. I'll be looking at it from the context of power pools. As we are all aware, the world is moving towards renewable energy and reduced emissions. So awareness has been building up in terms of initiatives. Lots of initiatives are already in progress. For Nigeria, we have the gas expansion project, which is geared at moving us away from the use of petrol and diesel into the use of CNG as transport fuel, that's a vehicle fuel, and LPG as cooking fuel. Then we also have the wind, the solar, and the water, other sources of renewable energy that are being looked at currently. And then for the African continent, this is in line, but we're trying to move towards the sustainable development goals, which we are aiming hopefully to achieve by 2030. Of course, we can say that for the Western nations, it's something that is very achievable, but for us in Africa, we know how slow we are in terms of implementation, so that's something that we generally will take our time to do. So for the African Continental Free Trade Agreement, looking at transition energy through the power pools, the previous speaker already mentioned the pools, the existing power pools using the West African, the West African power pool is consistent of 15 countries. I think Nigeria is part of that power pool. We have Niger, we have Togo. So how do the power pools work? The power pools work in terms of where a country like Nigeria will generate a lot of power, but we do not have the infrastructure to transmit and distribute the power. So we feed this power to the countries who have that distribution network or the network to receive our power, and then we get paid for that. If looking at it from the African Continental Trade Agreement perspective, we can see that that agreement is supposed to integrate trade or provide some kind of regional agreement between countries that are member countries of the trade agreement. And then in that kind of situation, we have the countries that have the power, that are transmitting the power to the countries that don't have the power. Now, where there is free trade between countries, we don't have the tariff problems, we don't have the movement problems, we don't have the policy problems. However, right now, the power pools as they are have their shortcomings, and I'll be talking through those points. One of the shortcomings I'll be referring to be insufficient investment in infrastructure. That has also been highlighted severally by speakers throughout today. And that is where a country like Nigeria, maybe we have the money, we have another country like Niger and they don't have the money, so they cannot put up the relevant infrastructure to generate or distribute or transmit power. So you have a country that puts enough money in their budgets for power projects, and you have another country that doesn't put enough money in their budget for power projects. So there is that gap there. And then we have the regulatory and institutional space, where we have policies where, like in Nigeria, I think that's a very Afrocentric thing, where you have a government that comes in with fantastic policies, and then you have another government that comes in 4 years or 8 years and changes everything around. So you have a situation where people don't want to put their money down, investors don't want to come in and put their money down. Even the countries don't even trust each other in terms of, if I do this one today and your president changes tomorrow, how can I guarantee that this our agreement is going to keep running? Then we have mistrust. Mistrust being, I mean, if power is a sovereign property of a nation. So Nigeria's power generation is ours, even though we sell it. Our fuel is ours, even though we sell it. When we begin to share it, and there is a situation where we can no longer meet that agreement, maybe a war or something, there's some kind of instability that makes us unable to meet what we have promised to give another nation in terms of sharing our energy. There's that mistrust. So people don't want to, other nations don't want to come and sign an agreement and say, okay, you're going to give me this amount of power every year. So we find that most of the policies that are there are very short term, because we have the political gaps, the policy gaps. We don't have policies that are geared towards the long term. Then we also have the political economy. We have a situation like Nigeria. I know that a lot of people think that power is expensive, but we know, if we are very honest with ourselves, that we do not pay what we are supposed to pay for power, because our power is heavily subsidized. We pay the barest minimum because the government subsidizes it for us. So if Nigeria, for instance, subsidizes power, and another country is not able to subsidize power, so it's more expensive in that country, we have all those gaps, right? So those are the problems that we have in terms of looking at it from a power pooling perspective. So when you bring 10 nations, 15 nations together and say we want to bring our power, want to share among each other, this is what we're going to do, these are the underlying factors that have made that not be so effective over the years. But when we come into the regime now of the African Continental Free Trade Agreement, we will be looking at another perspective. So we have signed agreements now, more long-term geared, between a number of countries, which means that an investor, let's say a power investor like Saipem is coming, and I'm going to put down some infrastructure here. I have some level of comfort that my infrastructure, if I say I'm going to be able to generate some kind of revenue or generate revenue or break even or whatever within the next 10 years, I can look at it and be able to say it's possible, because a group of nations have come together, they've signed an agreement or a treaty. So that means that even if Nigeria reneges, Ghana is not going to, it's not going to be across board. And I'm not a lawyer, so I can't really come from an arbitration or how the phrase you guys will use, litigation perspective. However, there are measures in place when those kind of situations arise, in the sense that if one country reneges, there are fallback clauses to which an investor can be able to be sure that their investment is still secure. Yeah, so that's for the investment opportunities. Then under the African Continental Free Trade Agreement, we also have a situation where the policies are more coordinated, because the countries have come together and said, okay, for energy, this is what we are doing. These are the policies and the regulations guiding. These are the tariffs. So there is some kind of coordination. And like I mentioned before, the coordination is mostly looked at more long-term, because the African Continental Free Trade Agreement is not a 5-year plan, it's not a 10-year plan. It's a plan that really doesn't have an end date. So there's a huge level of comfort in terms of when a policy is formulated, when a policy is put in place, it is going to run. If we change government in 2023, it's not going to impact what we have signed as a nation in terms of the trade agreement. And then also, we'll talk about building trust among the member states, because there are ways of dispute resolution that have been laid out. There's a framework for dispute resolution, and then there is there are related regulations, there are procedures and everything, and it's spelled out in such a way that everybody knows what it's supposed to be. So it's not a hidden document, it's not a secret document. For every sector that is covered, oil and gas, renewable energy, maritime, all the sectors, they have very clear laid down laws, they have clear laid down regulations. So everybody that is coming into that sector as a member nation, in terms of if we're forming a power pool, we know that if there is a situation that arises, this is the framework for our dispute resolution. We know that, so it's a transparent process, which makes it it's more comfortable for another nation to say, you know what, I want to be a member of this power pool. So that's for the building trust among the member states. So it ensures that all the interests of the stakeholders in every member region is aligned in terms of the regulations that have been put in place. So basically, yes, for a continent, we are still basically focused on our fossil fuels, and it's going to be that way for a long time to come. But like the previous speaker also mentioned, it's something that we, as a nation, at least for Nigeria, we have begun to build our power infrastructure side by side, while we are focusing on the renewable energy. We're still selling our crude, we're still drilling and we're still producing crude. However, we will not say that because we think that we are unable to achieve it within the time frame that has been given. It's I think it's 2030, that's the time frame for this SDG to be under full implementation. Definitely, I think it's something that we can do. And even if we think we cannot do it, we are going to be eventually forced to do it, because you drill your crude, yes. But when you don't have tankers to take your crude out, because everybody's now using electrical cars, eventually you're going to be forced to adopt to new technology, whether you like it or not. So at the end of the day, it's something that the free trade agreement is going to push us towards as a nation, Nigeria, as a continent in Africa. And then the collaboration that is going to be facilitated between the member countries is something that is going to address our energy deficit. So imagine where we're not flaring our gas, we're generating a lot of energy, and we're able to share this energy within a network of member power pools, member countries of power pools, and then we have sufficient light. I mean, it's a win-win situation for everybody who doesn't want to enjoy that at the end of the day. So for me, that's where I see, in terms of the African Continental Trade Agreement, that is where the power pooling is where we can actually grow. Thank you. The power pooling is where we can actually be able to fully harness the potentials in terms of our energy transition. So thank you. I'll be available to take questions now.
Thank you very much, Madam Uzo, for that presentation. She focused on the issues with respect to our the West Africa pool, and the fact that we already have a market as far as developing that space is concerned. Before I start asking all my questions, I want to open the floor for participants. Do we have questions? One or two? Okay. Maybe while I'm asking my questions, some questions would come to mind. So my major question will be more from the investments point of view, that, you know, seeing that you are into R&D and the likes. So can investment in gas help Africa's transition to renewables? If we just choose to focus more on gas, and because the International Maritime Organization has said by 2050 all ships should be driven by gas. So does Nigeria actually have an opportunity, a golden opportunity, to really cash in on gas and then use that to fund its renewables transition?
Okay, in response to your question, I'll say yes. And I'll say yes because we all know that 2020 to 2030 had been declared as the decade of gas. So we have government policies that are driving that pronouncement. We also have funds that have been made available through the National Gas Expansion Program to push gas infrastructure projects. We have a number of gas projects springing up. We see where companies are putting down money, because now you have a government policy that is driving. So you have companies putting down money, as investors are bringing in money to say, we're going to put down a power infrastructure. We have a lot of mini industries now being driven by LPG. So you don't have people running diesel generators in some factories and places like that. So I think that if the policies stay in place, the key is for the policies to stay in place. If the policies stay in place, investors will be more comfortable. And yes, from gas, we have more gas than we have oil. And like you mentioned, my company is a marine company, so we have vessels working offshore. But we know that in the short time to come, we're going to have to renew our fleet. We have to change our fleet, because with the carbon emissions, there's so many rules from IMO, and you have to start to make sure that you're in alignment with all those things. So, yeah.
Before I ask my next question, has a question popped up in any mind while those questions? Okay. My second question. So, if Nigeria is to focus on the development of gas, I don't know whether this is going to be a nationalistic question, because Leonard Silk said one of the problems with AFTA is that countries still have protectionist policies. But doesn't Nigeria stand a greater advantage to actually sell its gas to Europe? than to sell it to Africa in terms of being able to earn from gas, particularly if ships, most of which ship-owning nations are actually European nations. So if Nigeria chooses to focus on that, won't we actually make a lot more money in the short term compared to focusing on AFTA as a market?
Okay, so I think that we'll make more money from the European market, but I think that in terms of developing the African continent, it makes more sense to invest here. So there's no rule that says you can't do the two. So they can run side by side simultaneously.
Thank you very much. I think that's all from my side. Any questions? Oh, finally, somebody has a question. Yes. Okay. No, not a problem. Okay. Thank you very much, Madam. So please do stay till the end of the session. At this point, please a round of applause for her. Thank you. We'll quickly go on to our last speaker, Madam Patricia Igwebuike. Yeah, I hope I got that correct. I mean, I'm a Nigerian, I should make the effort. So I think she has a video for us. We'll quickly have that played before we move on to the closing session. Thank you. Can we have volume, please? Okay, so should we give you one more try? Okay. Kindly give us a few minutes. They're trying to sort out the technical issues with the video. Thank you. Okay. In the light of the circumstances, we would be wrapping up on this session, which essentially had us looking at the African Continental Free Trade Area Agreement, capitalizing on the agreement to improve Africa's energy transition. We looked at whether or not Nigeria should even invest in renewable energy and what the costs will be and if the benefits are well worth the try. We had amongst our speakers, Mr. Dolapo Akinrele, Senior Advocate of Nigeria, Mr. Francis Anatogu, the Senior Special Advisor to the President on private sector matters, and the Secretary of the National Action Committee on AFTA, who was ably represented by Mr. Michael Faniron. We also had Irogana Ogwefun, the MD and CEO of Stars Investment Company Limited, ably represented by Sophie Uzo, the Head of Research and Development and Projects at Stars, and my humble self, Foluke Akimoladu, as the moderator. Thank you for being an attentive audience, and we call this a wrap. Thank you.
Thank you so much, Ms. Akimoladu. We appreciate you a lot for creating time out of no time to moderate the session. We are really grateful. We know how very we know how very busy you are, and you flew all the way from Lagos just for this. We appreciate you. Thank you, Ms. Sophie. We appreciate you too. We know that it was a last-minute assignment given to you by Mrs. Iro, and kindly send our appreciation to her, that we're grateful that even when she was busy and couldn't make it, she sent you down here. And to our other panelists, we also appreciate you for coming in virtually. We knew it wasn't easy, but we thank you for coming. And to our lovely delegates that has been with us since the beginning of this conference till this moment, we want to say a very big thank you for your patience and your rapt attention and participation. We thank you for making this event a success, and we hope to see you next year. Bye.